For admission, item number 1.
Yes,
Your
Mr.
Lordship,
Jurumi.
I have filed my replies this morning. Can they be brought to the report?
You filed your reply today. It has come on record.
Has it come on report?
What reply?
In both, against the respondents 1 to 5 as well as the district respondent.
Mr. Albert. They have put the date, should have put 1st of September. Yes, it is there.
Hello?
It is there.
It is there. Now, my lord, my case is this. My property is private property. Therefore, the Public Premises Act does not apply to me. It is the admitted position, both by the union, by the railways, as well as by the state, that I have been in possession since the 1940s. Since the 1940s, my lord. And now, what the railways is claiming is that on the basis of a plan, nothing more, on the basis of a plan, this is railway reserve land.
Mr. Jimumi, the
Yes, sir.
question is not there. There's no quarrel that you have a patta in respect to the various darks. But here the question is as to whether you have any patta out there in dark number 10.
That is precisely the point, Your Lordship. So whether it is my Pata 131 or dark number 10, this land in question has been in my possession since the 1940s. Pata and dark number is a different issue, my lord. Pata and dark number is a different issue. Pata and dark number by themselves do not confer any right title or interest. Your Lordship is well aware of that. But the question is of possession.
No, Mr. Jimumi,
Yes,
patta confers the title.
My lord, but that itself is no proof of title.
That is the proof of title.
In addition to other factors, Your Lordship.
What other factors would be?
Possession, who is in occupation of the land?
Possession would be there, but possession does not confer title.
True, my lord, but possession is a reason for dispute to title. Possession is a reason for dispute to title. That Your Lordship will also appreciate that. Now, Your Lordship, beginning from 1982, in the Andhra Pradesh case, your own Supreme Court has held that where there is a dispute to title by way of possession, summary recourse under the Eviction Act does not lie.
There's no quarrel with that, but the question is as to whether you are there. Your entire basis out here is you are in dark now. You have patta in respect to those dogs.
Yes, my lord.
But the question is, they say that we have nothing to do with those dogs. We are concerned with dark number 10,
That's-
which is outside.
Then the flip side, my lord. I am also saying I have nothing to do with dark number 10. I'm also saying on the flip side, but
But Mr.
The land
Jimmy,
in question-
how can this court look into it when these you had a statutory appeal,
no, my lord.
remedy of appeal?
So therefore, my lord, the 82 case says, 82 case, dispute on the basis of possession, not pata number or dark number. There, the summary remedy under the Eviction Act does not lie. 2019, in the Chick case, the Supreme Court has interfered with the notice itself, where there is a dispute to title.
You don't have a dispute to title. Your title is in respect to other
No,
ducks,
no,
not on duck number 10.
No, my
And
lord.
they have come up after a demarcation out here. You got
No, there
you
was no
got the
demarcation,
evidence
my
from
lord.
them.
There was no demarcation. In my absence, demarcation was when, my lord? In the year 1964.
No,
Verified.
recently. Recently, this demarcation has been
No, my
carried out
lord.
pursuant to
No.
order being passed.
64, in the affidavit of the respondents 1 to 5. Your lordship will see when? 64 and 78. Not recently, your lordship.
No, the affidavit which has been filed out here.
Yes.
Category, this has been done in 2025.
No.
Yes.
The
The
main,
joint verification report is of 2025.
the main claim is on the basis of a plan drawn up in 1964.
Yes, that is how the railways do it. The railways have been
No.
given a plan.
The problem here, my lord, is this land has been in my possession since 1940. Since the 1940s.
So,
Since the 1940s.
so do you become the owner of the land on the basis of being in possession?
Yes,
And
my
that-
lord.
How?
Yes, my lord.
How? When the Limitation Act did not apply till then, how do you bring in the concept of 30 years?
Limitation Act applies, my lord.
Now,
No, even before.
no,
Limitation
Limitation
applies.
Act never applied in the state of Nagaland.
There is a judgment, your lordship, that the Limitation Act applied in the state of Nagaland pro prior vigor even before the state of Nagaland.
Show me.
I'll bring that, my lord.
I don't think so.
It is there, my lord. I'm sure of that. It is there.
No, it is not there.
It is there.
The Limitation Act could not have been applied because
And
the
not only
Limitation
that,
Act
my lord,
categorically said that it did not apply to Part B states.
there is a judgment, my lord. I'll bring that judgment on record.
Okay, 2 o'clock.
Not today, my lord. I have to go to
No, then I'm vacating the interim order.
No, your lordship.
Mr. Jimomi, I gave you the chance to your junior counsel yesterday before. You should have been prepared by now.
Your lordship, if I may, my land does not fall within the boundary of Dimapur railway station. My land is further down the tracks.
How on earth would this court consider this aspect in a 226 proceedings?
So therefore, my lord,
Therefore, the question is that you should have filed an appeal.
no, my lord,
Yes.
only if my land falls under the PPE Act.
No. You should have filed
No,
an
my
appeal.
lord, kindly look at the.
When you are raising certain questions of facts out there, better off, why don't you file an appeal?
So therefore, when there is a dispute of title, the Supreme Court has said, go to the civil
There's no
court.
dispute of title. They are categorically saying that we have
I am
nothing to
disputing
do
that,
with
my lord.
their land. We are
No.
concerned with Doc number 10. Isn't that
That's to
Mr.
differ. I am disputing that.
You are disputing, and how can this court decide? on
So
the
therefore, it has to go
26?
to the civil court.
No, you do. That is also a civil court. You kindly have you looked into section 10? Have you looked into section 10 or the public premises?
Yes, my lord.
What
An
is the-
appeal to the commissioner, my lord.
No, the appeal lies to the district judge.
District judge.
See,
Under the PPE Act.
yes,
Under the PP Act.
under the PP Act. See,
Your lordship, in the JIC case, the notice was interfered with and the party directed to go to the civil court.
no, it cannot be because you kindly see this.
My lord, we kindly have a look at the JIC case then.
No, I have seen the 1982 judgment of Andhra Pradesh which went to Supreme Court, but have a look at section 10.
Section 9, my lord?
Section 9.
Section 9. An appeal shall lie from every order of the estate officer made in respect of any public premises under Section 5 or Section 7 to an appellate officer who shall be the district judge of the district in which the public premises are situated, or such other judicial officer in that district of not less than 10 years standing as a district judge may designate this.
So your appeal lies to the district judge.
My
The
lord.
district judge can very well look into it. This is what is being done all along. Because these are questions of fact which this court cannot touch. Now, these are evidence which are there. Go there and file it out and say that this. Then he can very well ask various aspects. He can take evidence also,
My lord.
which I cannot take evidence
True, my lord.
as to whether you are
That
in
part I
possession.
appreciate.
How on earth will I know that you have been in possession for the land from 1940?
That part I appreciate. That part I appreciate.
Then-
But the only thing, my lord, is that
Let
in
me
the
give you
case,
how many days is there limitation?
In case of an appeal from under Section 5, within 12 days.
12 days. So 12 days I give you, go and file an appeal. That's the only way.
Well, if that is how my lord is looking at the matter, very well, my lord. I'll do that.
Huh?
That is how my lord is looking at the matter, I will do that, my lord.
Because you see, what you are saying, you can very well bring it by way of evidence there.
That I can imagine.
that you have been in possession from 1940. This land could not have been allotted, and if it had been allotted or acquired, then you have a right of compensation. This is your prayer.
Yes, my lord. That is my.
So therefore, whether section 10, whether dark number 10, you may have been in possession. You may not have a right over the dark number 10, but you may have been in possession from the last 90 years. Although you may not, you are not 90, I suppose.
No, my lord, my case was that I was just relying on the AP case as well as the check case, where the notice itself was interfered with.
Yes, if it is a question of when, as regards disputed questions on title,
Yes, sir.
then obviously you can go there. You have the court, the jurisdiction of the estate officer is out.
Right.
But here on the facts, they say this, and you have not. Well, what is your reply?
I have said, my lord, that it is the same plot, whether it is Pata 131 or dark number 10. It is
So
the same plot.
therefore, the district judge can very well direct. Then look here, you go into this.
Yes,
You see, this is the patta. The patta is in respect of dark number 19, 25, 251, 254, 256. The verification which have been done recently show that the land does not fall in these darks.
My lord,
This is the verification.
my lord.
So these verifications which are there, and they are therefore not saying that we are touching on these darks. We are doing into respect of dark number so and so. Now you claim a right of more like a adverse possession,
My lord.
an adverse possession over the land.
In a manner of speaking, my lord.
If you don't have title, the only way is adverse possession.
No.
So if it is adverse possession, then you have to
But
show
it is also my case, my lord, that in the resettlement operations in the Democrat, frequent resettlements, the dark number has changed. Otherwise, it is the same plot.
So you have to, but that is what has been shown, that this is not the dark number. We are not
Yes,
concerned with
I
this.
have said that in my counter, man. I have said that in my counter.
Sure.
My lord, your lordship, just one point. What is happening in the Dimapur area is that there have been multiple land resettlement operations. In these resettlement operations, things have not been fair or transparent. Dark numbers have changed, Pata numbers have changed, plus have been shown here and there for vested interests.
But the fact remains, you have been given a patta number
My
131.
lord,
This was given in 1969.
my lord.
Now, at that point of time, this particular, do you have a problem as regards the demarcation? Then obviously the revenue officer has to be brought into the notice of that. Do you take any steps for that?
I have said in my counter that I came to know about this change in the dark number only after the affidavit was filed. Not before. Never before.
So better there. I
Yes,
can
sir.
look into this.
Yes, my lord. I understand that, lord. That I understand.
Heard Mr. A.J. Mummy, the learned counsel, appearing on behalf of the petitioner. Mr. Y.P. Gupta appears on behalf of the Railway Administration.
Yes, sir.
And Mr. So-and-so appears on behalf of the state respondents. The petitioner herein have approached this court by invoking the jurisdiction under Article 226 of the Constitution, challenging the order passed under Section 5 of the Public Premises Act. Madam, you look into the whole name of the Act 1971, whereby there has been, whereby Public Premises Act 1971, challenging the order dated
16/12/22.
challenging the order dated 16/12/2022, passed by the, where's the estate officer respondent number?
Yes, the respondent number.
The problem is you don't make the estate officer a party. He is the main person.
Respondent number 4, my lord. Review manager / estate officer.
Okay, but passed by the respondent number 4, whereby the petitioner herein has approached this court by invoking the jurisdiction under Article 226 of the Constitution, challenging an order passed under Section 5 of the public order dated 16/12/2022, passed by the respondent number 4 under Section 5 of the Public Premises Eviction of Unauthorized Occupants Act 1971. First, the case of the petitioner herein is that the respondent, that the land wherein the respondents have passed the order dated 16/12/2022 falls within the land of the petitioner
Yes, ma'am.
in patta number
131.
131 issued to the petitioner on 1/8/1969, containing the dark numbers 19, 25, 251, 254, and 256 of Dimapur Town Block number 3. Pusto. Per contra, it is the case of the respondents numbers 1 to 4, 1 to 5, that the land which in respect to which the impugn order dated 16/12/2022 was passed do not fall within the ambit of the patta number 1 dated 1/8/1969, and more particularly in respect to the dark numbers contained in the said patta. It is further seen from the affidavit which was filed by the respondent numbers 1 to 5, respondent numbers respondent number 7, that pursuant to certain directions passed by this court, field verification was carried out, wherein it was found that the land in respect to which the impugn order dated 16/12/2022 was passed falls in dark number 10, block number 3, cadastral area Dimapur, at measuring 50,286 square feet, or 3 bighas, 2 kathar, 9 lechas. It has also been mentioned in the joint verification report that the Sita, as per the Sita records, dark number 10 is recorded as railway reservation area. To the said joint verification report, the map of the Department of Land Survey, records and survey of the government of Nagaland have also been enclosed. To the said affidavit in opposition filed by the respondent number 7, affidavit in replies have also been filed by the petitioner, wherein a stand has been taken that the petitioner had only come to learn, pursuant to the said joint verification report, that the land which is under occupation of the petitioner falls in dark number 10. It is the further case of the petitioner in the affidavit in reply that the petitioner has been in occupation of the said land. Petitioner as well as his forefathers have been in occupation of the land since 1940.
1940s. Not exactly 40s.
40s, 1940s. And as such, the reservation so sought to be made in respect to the said land in favor of the railways is illegal. Mr. A.G. Maumey, appearing on behalf of the petitioner, further emphasizes that during the recent settlement operation being carried out, there has been various illegalities in preparation of the map and as well as the settlement proceedings. Thereby, the land of the petitioner have been brought outside the patta number 131 and separately marked as dark number 10. So this court have duly heard the learned counsels appearing on behalf of the petitioners, and the facts which appear from the materials on record show that on one hand, the petitioner herein claims that the land which is in possession of the petitioner is a part of Dag number 1, Patta number 131. Whereas the verification which have been carried out by the respondent authorities, more particularly the respondent number 7, clearly shows that the respondents number 1 to 6, 1 to 5, no?
1 to 5.
1 to 5 have not taken any action in respect to the land falling within the patta of the respondent number of the petitioner. Rather, the land which have been illegally occupied, this land has been illegally occupied. The land which have been specifically reserved for the respondent numbers 1 to 5 have been illegally occupied by the petitioner. It is the opinion of this court that from the materials on the record, it does not show that the facts are that the title of the petitioner in respect of Dag number 1, Patta number 131 have been disputed. The only issue is as to whether the petitioner is in occupation of the land which have been specifically reserved for the railway administration. First, these facts under such circumstances, the question of dispute in title does not arise. What arises, on the other hand, is as to whether, as regards the identification of the land, this court further takes note of the section 9 of the PP Act specifically provides an avenue for filing an appeal against an order passed by the estate officer under section 5 of the Act of 1971. The said appeal, in the said appeal, all these aspects can be very well dealt with. Under such circumstances, it is the opinion of this court that it would not be proper on the part of this court to exercise the extraordinary remedy when there is an effective and efficacious remedy, efficacious and alternative remedy available to the petitioner. This court further takes note of that the time period for filing the appeal in terms of section 9 of the Act of 1971 is 12 days. Considering that this court is not exercising its statutory remedy, its extraordinary jurisdiction in the present dispute, this court grants the liberty to the petitioner to avail the remedy in terms of section 9 of the Act of 1971. It is further observed that if the petitioner herein avails the remedy by filing an appeal within a period of 12 days from the date of the present order, the learned district judge, the principal district judge, the principal district and session judge, Dimapur, shall decide the said appeal on merits without insisting upon the question of limitation.
Let's ask for further indulgence. Just one point.
During this period, for the next 12 days, there shall be a stay to the order dated 16/12/2022.
One additional point, Manoj, if I may again. Manoj, the railway reserve area. My issue is that for it to be railway reserve, it must be built on a foundation. I'm saying it has not been done in accordance with law. That issue may also be kept open.
All are open. I've never said anything. So the learned district judge shall decide the said appeal without being influenced by the observations made here.
Much more
Obliged. For admission, item number 2.
Yes, what is this? It is seen that in the cause list, the names of the learned counsel for the petition as well and newly have not been reflected.
Your Lordship, on the last date, respondent number 5, the principal accountant general has
You
also
are
had a party.
petitioner,
Yes, Lordship.
you are nowhere to be seen when a matter is called.
My apologies, Lordship.
Then tell me, you are
Yet to receive
entitled
the
to
copy of the
receive the
petition,
pension.
my lord.
Your pension has not been given.
Yes, Lordship.
Have you given him a copy? To
Copy
Mr.
of the petition
Seki.
may kindly be furnished to me.
I'll finish the copy to the Lordship.
Why have you not done? You have got himself impleaded.
Lordship,
Madam.
I've been
Isn't it a
recently-
case of pension? You should think about your client, isn't it?
Apologies, Lordship.
Or
but
do you want
I've
that
been
this
rec-
court should make photocopies of this and give it to Mr. Seki?
Yes, Lordship.
I should.
My lord.
No,
Then the counsel appearing on behalf of the petitioner submits that during the course of the day, 2 copies of the writ petition would be served upon Mr. J. Seki, the learned counsel appearing on behalf of the respondent number 4 and 5.
Not 4, your lordship. Only 5.
Okay, respondent 1 copy, and who is 4?
Yeah.
You are there? You have also not received copy? Okay, will serve extra copies of the writ petition upon Miss Esang, the learned counsel appearing on behalf of the state respondents, as well as Mr. J. Seki, the learned counsel appearing on behalf of the respondent number 5. First of, 4 weeks' time is granted to the respondents to bring on record their stand by filing the affidavit. List this matter again on 25th of September 2025. The affidavits be filed. 4 weeks now, 3 weeks time. Be filed by 22nd of September.
Lordship.
For admission, item number 3.
Yes, Mr. Counsel,
Lordship. If,
your brief is always so big. What is wrong?
Lordship. Lordship, on the last occasion, I was directed to file a.
How many people? Your petition is smaller than the name of the parties.
Yes, Lordship, there are 43 petitions, Lordship.
What is the case?
Your worship,
Regularization.
Lordship, as per the standing wine, Lordship.
It's very difficult. Why are you filing all these people together? Tell me. It's very difficult.
Lordship.
That day somebody filed one petition, it becomes so difficult, it means it is not possible.
Lordship, but then, Lordship, while pending application, some of the petitioners for regularizing, Lordship.
I would not pass any other judge, let them pass orders. I am not going to pass which, how many petitioners are there? 49.
43, Lordship.
49,
43, Lordship.
43.
Lordship.
What has happened? In the meantime, somebody have,
Lordship. Some of them were given benefit, Lordship.
huh? 43. Madam, you have filed your affidavit?
No, Lordship. It's
Okay,
in
take
regulation.
how many? 1 year?
3 weeks, Lordship.
No. Take a year. Then they will realize. In the meantime, if you can complete it, complete it. We fix it on 1st of September 2026. The petitioner has filed an amended writ petition on 11th of August 2025. Ms. So-and-so, appearing on behalf of the state respondent, submits that she would like to file an affidavit. List this matter on 3rd of November 2025. In the meantime, the state shall file the affidavit on or before 29th of October 2025. Full stop. The pendency of the writ petition shall not, however, be a bar on the part of the respondents to consider the case of the petitioner for regularization, subject to the petitioner being eligible in terms with the office memorandum dated 17/3/2025. Next.
Lordship, 15. 2015.
15. Full the council this court further directs the respondent state to bring on record what steps have been taken as regards the regularization, as regards the proposal, as regards the implementation of the office memorandum dated 17/3/2025 in the case of the petitioners by way of the affidavit.
Legislation.
For admission, item number 4.
Please, Your Lordship. Your Lordship, I'm challenging the wrongful termination of the service of the petitioner, which is at Annexure 12, my lord, page 44. May I read, my lord?
Please, page,
Page 44, my lord. Annexure 12.
as per section 3D of the Defense of Iman Act, so Deputy Director Zial so is hereby released from service on Iman on completion of 5 years of service. Okay,
May I take your lordship to the notification based on which?
let us see your appointment then.
Yes, your lordship. My lord, my appointment is at page 19, my lord. Page 19. No, your lordship, page 23. Page 23.
On recommendation of the selection board of the so and so on its meeting so. The post of year terms and conditions, the terms and conditions are given under tenure of annexure shall be for 2 years from the date of so and so without contract allowance, subject to termination within 1 month's notice. Joining time, scale of pay. So comment, okay. Then,
Now, my lord, if my lord says my.
so it is more like a contractual appointment.
Yes, your lordship.
Then,
But after the defense service is such that there is no regular appointment extendable till the age of 60, my lord. Now, my lord, here, the rank of the petitioner in the order dated 1st November 2024, at page 44, which my lord has already seen, the rank is specifically mentioned as deputy director. The section 3D of the section 3D of the Ministry Defense Government of India's guideline dated 13th November 2020, 13th August 2024, my lord will see that this is particularly for a post of director, not for a post of deputy director. All the similarly situated persons like the petitioner are all serving till the age of 60, my lord.
how?
Let us read the notification, my lord.
Okay.
At page 37, my lord. Page 37, annexure 10. This is 13th August 2024. It's a guideline, my lord. Shall we directly go to 3D, my lord? If my lord may allow.
3D.
3D. The tenure of director, Sainik Welfare Comes Secretary, Rajesh Sainik Border ZSWO, will be for a period of 5 years or 65 years of age, whichever is earlier, subject to the satisfactory performance of the concerned officer. So this is concerning only the post of director. But based on this notification, the petitioner has been wrongly terminated from the contractual service, my lord. It is not a case where his performance was not satisfactory. It is only by quoting the wrong guideline that the petitioner has been terminated. Then, my lord, may I kindly come to the first annexure.
But tell me,
Yes, sir.
where is your extension beyond 31st of August 2024?
Your lordship, there has been constant.
Where is your extension?
Yes, your lordship.
No extension.
No, why not, your lordship? There has been extensions, your lordship.
Page 43. After that, where is the extension?
Your lordship. Your lordship, he was reappointed again. He was released and again reappointed in the year 2024, your lordship. Few dramas have unfolded where he has been wrongly terminated by quoting the wrong provision of law.
That is immaterial. That is not a question now. That is, but the fact remains that can you be extended? Means
Yes, your
it is a contractual appointment. You can be terminated. But the question is whether the termination is with a stigma. That is the question. Otherwise, you cannot.
Yes, your
The
lordship.
question, there is no stigma.
My lord has seen the page 43 annexure 11 also. This is the extending the service of the petitioner with effect from 1
This is for you
2024.
to get the benefits for that period. Otherwise, your period was ending on 15th of March, 1st of March, 28th of March, February.
Now, your lordship will kindly appreciate this. In my additional affidavit, I have brought several documents on record to show that similarly situated persons, some are still continuing. Now, my lord, it is not a case where I have reached the 60 years of age.
No. You see, it is like this, either 5 years or 65 years.
No, your lordship, that is only to pertaining to the post of
Understood,
director.
but the question is, it's something like that. Tomorrow, can you say out there, then look here, for the purpose of the president of the, or let us take the case of a Lokayukta. The Lokayukta or Human Rights Commission chairman, they are given 4 years or 3 years or 65 years. Now tomorrow, they said, okay, 3 years is over. Who?
Your lordship, the guideline based on which I was appointed is at Annexure 1, page 19.
Let us see that.
Your lordship. Page 19, Annexure 1.
This is the same director. May continue up to 60 years. Of Iman satisfactory Iman, the tenure of the director will be for a period of 5 years.
Yes, director is for the number of years limited, it's for 5 years, your lord.
So under what provision you have been appointed then?
Your lordship, it is a lengthy guideline. If we read through, your lordship will kindly appreciate that. Particularly for the post of director, there has been limitation because director is also the secretary of the Rajya Sainik Board. The others,
Station of the so-and-so defense Ministry of the point. Training to the post of Zilla Sonic Welfare Officer and will function as head of the office and DDO in respect to it. Now, where is your appointment for the purpose of deputy director?
your lordship, my appointment order is at Annexure 2, page 20.
No. This is for some Zilla Sonic Welfare Officer.
Yes, your lordship. So that is in the rank of deputy director.
No.
I was appointed in the same rank and
Where is your extension, subsequent extension? Deputy Director here. Kindly come to 29th February 2016, page 25.
my lord,
Names of selected of the so-and-so in case of non-available with clean record on so-and-so for the post and contract service period of a retired officer selected for the post shall not be more than 3 months so-and-so. Office so-and-so stenographer dispensation.
my lord is looking at the state's notification.
Yes.
Yes, your lordship. D. So Zilla Sainik Welfare Officer and Deputy Director, they are in the same rank, my lord, as my lord has already seen. But my lord will kindly appreciate the ceiling is only to the age, not for the number of years of engagement as far as it is not a post of the director.
You were earlier released from service.
Which page, my lord?
Page 28.
Yes, your lordship, this is what I'm trying to convey to your lordship. Now here, the law that has been quoted is the Nagaland Retirement from Public Employment Second Amendment Act 2009, which is not applicable at all to the petitioner. This is also up to the age of 60 years.
But then they regularized it.
Your lordship.
They have regularized it.
Now, even now, the section 3D in the guideline that has been quoted, it is only for a post of director where it is up to 60 or 65 years. Now, my lord, especially for a post of director, my lord will kindly appreciate this. Those who have served the full years of service in the army, they retire in their late 50s or at the age of 60, my lord. Here is an officer that has many more years to reach 60, my lord. He's still in his 40s. So unless His performance is not satisfactory and there are some complaints against his performance as an officer. My lord, the ceiling is only to the age limit, the higher age limit, not for the number of years of engagement until and unless he completes 60 years of age.
So you mean to say that you cannot retire?
No, your lordship, I will retire, but according to the,
When?
no,
As per what?
your lordship, as per the government's notification,
Show me which notification that you can continue for whatever age you are like.
no, till the age of 60, there is a bar, there is a ceiling. My lord has already seen page 37 also, my lord. Page 25 also, my lord has already seen.
Where is it that 60?
My lord, at page 25, which my lord was reading earlier, annexure 3, page 25, this is the notification issued by the Government of Nagaland Directorate of Sainik Welfare and Resettlement. B, my lord. Additional Director, page 25, my lord. Additional Director, Deputy
Zilla
Director,
Sainik Welfare.
Zilla Sainik Welfare Officers. These
So
are in
Deputy
the same
Director
category,
is
lord.
not there, so the question is of you are a Zilla Sainik Welfare Officer. For
Your
the
lord,
post of age minimum 50 years, educational experience should have been during the
no, your lordship,
preference to.
my lord is reading the other,
Wait, let me see.
my lord.
The post of additional deputy Zilla NESM officer so and so man. The age of the candidate shall not be more than 59 or not Christian women, not more than 60 years on the nation. Yes, who is appealing for? Yeah, government. What is your stand?
May it please my lord. The matter in brief is the petitioner was appointed not only in 2016, but he was initially appointed by order dated notification 23rd October 2008. That is annexure A to my affidavit in opposition at page number 8. Page number 8.
Actually, what is the name of the petitioner?
May I read, my lord?
Oh,
My affidavit in opposition
Achumi.
filed on 11 June 2025.
22nd of October 2008.
Yes, my lord.
For 2 years only. That is from the date of joining.
Yes, my lord.
Hmm.
And thereafter, for a period of 4 years, his service was not extended. However, by another notification at running page 15 of my affidavit in opposition, order dated 25th April 2016.
Then again, every 2 years you have extended.
Yes, my lord.
But these are all post facto approval.
Yes, my lord.
Post
Yes, my
facto,
lord.
because on
Only
2000
through the recommendation of the selection board. He had not only served 10 years, but he served for 12 years. And his last extension,
No, not 12, more than that.
yes, my lord.
He was
And
appointed in 2008.
yes, my lord.
Then
But there was a gap of 4 years.
4 years.
Yes, my lord.
Okay.
And the last extension order, which is at annexure E running page 34 of my affidavit in opposition. May I read, my lord?
31st August,
Yes, my lord.
on completion of 5 years of service.
Yes, my lord.
Then, now what does the petitioner want? Wrongfully terminated.
Extension of service was granted on the basis of his application, on the prayer of his petitioner's application. But once it is not considered, and if he feels agree, then he can face another selection board. But as per the first appointment order notification, which is at page number 8 of Annexure A of my affidavit and opposition, he was appointed specifically for a period of 2 years from the date of training. And
2
time to time,
Period of 2 years.
only 2 years, my lord, on tenure basis. On the recommendation of the selection board for Raja Sainik Board, Nagaland, held on 16 May 2008, the governor of Nagaland is pleased to appoint the undermentioned retired army officer. The type copy is at page 11, my lord. Type copy of my affidavit in opposition is at running page 11.
So the last extension is at page 20 of
Yes,
your affidavit. This
no,
is
my
the-
lord.
this is
Page
the-
34,
No, 34 is the release.
release
34
order.
is what he is challenging. Twenty is the period now whereby you have extended till 31st of August 2024.
Yes, my lord.
And you have released him by Annexure E.
And my learned friend's contention is he was wrongly released with effect from 1st November 2024. However, his release order was with effect from 31st August 2024.
No, it is
After
the
serving for a period of 10 years. Apart
the order
from
date is
2
1st
years
November, my lord.
services rendered prior to his 10 years of service. So, my lord,
You want another 12 years.
Your lordship,
No,
that is just
that
their
seems to be,
interpretation. I can show your lordship with in my additional affidavit the documents on how they have engaged. My lord,
No, they have engaged or not, I'm not concerned, but the fact remains these are contractual services. So you are given for a particular term, they may have not extended it, but if they have not extended it, then they have not extended it. For that you may, how can this court pass a direction for them to extend it?
your lordship, the
It's not a case of termination,
your lordship,
it's a case of not a non-extension.
yes, ma'am.
your lordship, extend whether the service to be extended or not. It depends on the performance of the officer. So here is not a case where
Why
there is
did
even
you
a single
file
complaint.
petition?
Your lordship,
Why did you file the writ petition?
In
You
fact-
should have not filed the writ petition. You should have consulted them. All these extensions are given post facto. You shouldn't file this writ petition. You have now angered this, the big, you have woken up this lion out there in Mr. Santham.
your lordship,
Yes, my lord.
may I take your lordship to my annexure 1?
Have Mr. Seki, have you
My
seen
lord.
all the orders by which you have been extended? All these extensions are after 3 months, 4 months, or 6 months after the period.
Your lordship, as far as the engagement is concerned, except for the post of director or come secretary Zilla Sainik Board, my lord will kindly appreciate this point. The ceiling for engagement is up to 57 or 60 years. As far as the number of years of engagement is concerned, from the terms of and condition of the appointment itself, the extension will be granted unless there are some issues with the performance or other disciplinary issues of the employee, your lordship. So, my lord, when no such complaint, not even a whisper of complaint is there against my client, the petitioner, how he has been released from service. That is what I'm questioning.
But this is not stigmatic.
Your Lordship, when my client is the only person that has been targeted and similarly situated persons are all continuing in
No, my
service.
lord, those are not the Zila Sainik Welfare Board officers. They are grade 4.
No, Your Lordship,
You want to be a grade 4?
they're all in the same, they're all covered by the same guidelines, Your Lordship.
No, Mr. Zakir, no. Mr. Santam, kindly show me why you have not extended it. Where have you mentioned in your affidavit why you have not extended it? That would be helpful for dictating the judgment.
He had been given series of extension of service for a period of 10 years,
12 years.
12 years,
No,
including
more than that.
Yes,
2008 to 2024 is 14 years plus 2 years. 16 years. Or 4 years is in the meantime,
Yes,
so
ma'am.
12 years.
and this being a purely contractual service. Petitioner doesn't accrue a right.
No, show me where is your explanation out here, the reason why do you don't want to extend it?
He was appointed specifically for a period of 2 years, and subsequently his service was extended from time to time, and last extension order was given. He was released with effect from
The
31st August.
may not have
2024.
a right to seek an extension.
Yes, my lord.
You may not have a right. It is absolutely within the domain of you.
Yes, ma'am.
But he has a legitimate expectation that you will consider him for an extension.
And Your Lordship,
It is
condition of the appointment is that notice also should be issued from either side 1 month. My Lord, no notice has also been issued against me.
If you are terminated in between,
My Lord,
my lord.
I am trying to help you out, Mr. Seki, to get some reasons from him.
My lord, here in page number 21, annexure P, the petitioner had been submitting his application for extension of service from time to time. But after the expiry of his 31st August 2024, he has not submitted any such letter for extension of service.
You have not?
Your Lordship, I have submitted.
So we close this on that basis. You file an application for extension, they shall consider. Matter over.
My Lord,
If the grievance of the respondent is that you have not filed any extension application,
Your Lordship,
then
actually
you
I have
file an
submitted.
application seeking extension.
May or may not.
And they may or may not, they will
Yes, my
consider.
lord. Yes, my lord.
And once their consideration, then they have to give reasons.
Your Lordship, at page, annexure 7, page 33 also, the petitioner's representation dated 26/3/2024.
Page,
Page 33 and 34, Your Lordship, page 33. That is one representation.
to direct a wrong release from the post of Iman before 60 years and issue a fresh appointment letter as erstwhile upgraded post to Iman so and so fixed on honorarium. Other verb mentioning one so and so, hence so and so. Wrongly releasing from me. So. Here, this is not an application for extension. This is what they did.
Yes, my lord.
They allowed you to continue to work till 30th of August,
31st of August. Yes, Your
31st
Lordship.
August.
Then, my
And
Lord,
thereby, they also regularized this period.
Your
So
Lordship.
after 31st of August, what have you done?
My Lord, again, another representation at annexure 13, page 45.
Page?
Page 45, my Lord.
In page 45,
After the termination, Your Lordship.
representation. Mister, how
Lord.
is it possible? What you are asking? You are 48 years. You want an extension for 12 years.
No, I'm not asking for a continuous extension till the age of 60
Page
years,
47, paragraph 10.
Your Lordship. Your Lordship, as far as the year of engagement is concerned, they may extend from time to time till the age of 60 years,
Now, the question is, you see, you are contractual appointees.
Your Lordship.
Their stand is that you have not asked for extension for 2 years. Every 2 years you are sought for an extension, you should have asked for extension. You have not. If you have not asked for an extension of 2 years, but you want the extension for 12 years, then how is it possible?
So, Your Lordship, regardless of whether it is a post of Zilak Sainik Welfare Officer or Deputy Director or the lower rang officers who have been engaged in other trades,
Show me
Your
a
Lordship.
judgment by which I can pass an order directing them to extend. Show me.
In
You have
case
been
of wrongful
released.
termination, Your Lordship,
It's not a wrongful termination because you have been released from the period after the extension, on the date on which you completed the extension.
as far as the case relating to Raja Sainik Board engagement, Your Lordship, I do not have any particular specific
Show
judgment. at the
me
moment.
any judgment of the Supreme Court whereby there is a direction that after the period is over, the court directed that kindly give him extension. One judgment.
Can we take up on Thursday, my lord?
Why? Because that's the last date for me.
I will bring
cannot
the judgment, Your
deliver the
Lordship,
judgment.
just to place
I
the
have
judgment.
already marked out 6 or 7 matters on 4th. So
I'll place judgment before Your Lordship on Thursday.
only one. 2
My lord.
o'clock. 2 o'clock. You are a very efficient lawyer. They'll find it out by 2 o'clock. One judgment. I'm telling you.
Then tomorrow, my lord.
Because the Supreme Court has been categorical
My lord.
that there cannot be a direction when there is a question of here. Yes, if the termination is illegal or if the action is illegal, you may strike it out. But I can't issue a mandamus.
Your Lordship,
But it is not illegal, taking into account that the period is over. And as I said, Mr. Santam has made a very important submission. He said that you have not sought for extension. Let me note it that you have not sought for extension
no, Your Lordship,
and give you the liberty to seek an extension and then to consider that. He is giving you the leeway. You don't have a case, but he is giving you the leeway. You are seeking an extension for 60 years. That's not possible, impossible. Nobody will give you.
then my lord, I'll ask for extension.
Yes, you should
Your
ask.
Lordship.
He says that no extension has been sought for. So taking he as representing them, I give you the liberty to seek an extension.
My lord.
They
my-
don't extend, then it gives you a cause of action that I have sought for an extension pursuant to an order passed by
Your
court.
Lordship.
They should have considered fairly, taking into account the other aspects, and extended me.
Your Lordship.
That should be then you get a cause of action to come back again.
My lord.
My lord, he's bargaining with the employer without seeking a remedy, challenging the authorities' order. So what I'm trying to impress upon this honorable court is, should he submit application for extension of service by way of another selection board, he may or may not be selected. However, liberty may be granted so that he may.
So he will ask for extension.
Yes, ma'am.
They will consider.
Yes.
And in terms with the extent policy, they will consider. They will consider, and then
By another
whenever it is
notification,
agreed, I'm always sitting here for Mrs. Jesaki to come back.
My lord.
Chalo, let's dictate. Heard Mr. Jesaki, the learned counsel appearing on behalf of the petitioner. Mr. A. Santam, the learned additional advocate. Your additional advocate general.
Yes, my LT Sangha.
Additional Advocate General appears on behalf of the respondent numbers 1 to 5, 1 to 4, 1, 2, and 3. You are appearing for 4 and 5, no? Mr. Young.
For 5 only.
1
Union
to
Evidence.
4 and Mr. Yangawati appears for respondent number 5. Yes, Mr. Yangawati, do you have anything to say?
No, I have nothing.
Okay. The petitioner herein is aggrieved by the order dated 1st of November 2024, enclosed as Annexure 12 to the writ petition, on the ground that the petitioner had been released from service with effect from 31st of August 2024 on completion of 5 years of service. Mr. J. Seki, the legal counsel appearing on behalf of the petitioner, submitted that the impugned order dated 1st of November 2024 is required to be interfered with, taking into account that a provision have been, the petitioner have been released from service but on the basis of a provision which is only applicable in respect to the director
My lord.
and would, however, not be applicable in the case of Deputy Director / Jilla Sainik Welfare Officer.
My lord.
The legal counsel appearing on behalf of the petitioner further submitted that the petitioner was appointed as the Jilla Sainik Welfare Officer, and as such, the petitioner has a right to seek extension that has a legitimate expectation that his services would be extended from time to time till he attains the age of 60.
My lord.
However, the respondent authorities have not considered the same and released the petitioner. Full stop. Par contra, Mr. A. Santan, the learned additional advocate general, submits that the petitioner was initially appointed in the year 2008 on 22nd of October 2008 for a period of 2 years. Thereupon, there was a gap period of 4 years, and again the petitioner had been re-engaged on contractual basis for a particular period of time. Full stop. Every time, the legal counsel, learned AAG, further submitted that every time, as would be seen from the materials on record, that the petitioner have sought for extension, and accordingly extension have been granted. The legal counsel further submitted, learned AAG further submitted that the petitioner's extension ended on 31st of August 2024, and there was no further extension granted for which the petitioner was released from service with effect from 1st of November 2024. The learned counsel, learned AAG, further submitted that the petitioner have not even sought for extension as per the format as well as in the manner in which it should have been sought for. On the other hand, the petitioner had submitted a representation claiming that he should be extended, his services should be extended up to 60 years, which is not permissible as per the extent policy. Full stop. This court inquired with Mr. J. Seki, the legal counsel appearing on behalf of the petitioner, as to whether the petitioner have sought for extension, inasmuch as it is seen that on earlier occasions that the petitioner have been seeking for extension from time to time, and the extension have been duly granted. The legal counsel has drawn the attention of this court to the representation submitted on 4/11/2024 to the Home Commissioner, Government of Nagaland, and submitted that the due representation have been submitted, but the same have not been considered. This court have duly perused the representation dated 4/11/2024, and from a perusal of the said representation, it is seen that the petitioner have, instead of seeking extension for a period for a period of 2 years, which is the normal practice, the petitioner have sought for that he should be extended, his services should be extended till 60 years, as per the existing policy that was followed and implemented by the state government in the past. Full stop. The learned AG, on the other hand, further submitted that as per the guidelines dated 13/8/2024, issued by the Ministry of Defense, Government of India, there is a manner in which the petitioner, the post of the Jila Sainik welfare officer has to be filled up. And he further submitted that the same would be done on the basis of a selection proceedings to be conducted by the selection board in terms with clause 5 of the said notification dated 13/8/2024. He submitted that if the petitioner seeks an extension, he is at liberty to file such application. And if such application is being filed, the respondent authorities shall duly consider the same in terms with the notification, the circular dated 13/8/2024, as well as the extent policy. First, this court, having perused the materials on record and having heard the learned counsels appearing on behalf of the petitioner, finds it relevant to observe that the petitioner initially was appointed on 22nd of October 2008 for a period of 2 years. Thereafter, the petitioner services have been extended from time to time. And as on date on which the petitioner had been released from service, the petitioner had already rendered 12 years of service, taking into account that 12 years of service. First of all. This court, Mr. Jaisaki, the learned counsel appearing on behalf of the petitioner, further submits that in the meantime, the petitioner have also attained the age of 50. Otherwise, you don't become qualified.
Yes, Your Lordship, 49 or 50. This is
Kindly come to page 39.
49 years, Your Lordship.
You'll become 50 here now. 50.
He was 48.
Nearing
yes,
50.
Your Lordship. Yes, nearing 50.
And as per the notification circular dated 13/8/2024, the minimum age as on the crucial date would be 50 years for the post of Jila Sainik Welfare Officer. So, taking into account the above, taking into account that the submissions so made by the learned AG, the respondent shall duly consider if due application is filed seeking extension and due seeking extension, this court, without interfering with the communication dated 1st of November 2024, grants the liberty to the petitioner to file an application before the concerned respondent authorities seeking extension of his services, seeking extension extension or oblique? Seeking extension, no?
Yes.
My lord.
Seeking extension of a service. As was done on the earlier occasions.
My lord.
And the concerned respondent authorities, and more particularly, who will consider this?
By the
Your
chief
lordship,
secretary.
the Home Commissioner,
Chief secretary.
Concerned respondent authorities, more particularly the respondent number 2 and 4,
3 and 4.
shall duly consider the same
yes, your lordship.
as per its extent policy and guidelines, EXTAND. Full stop. Liberty given to the petitioners to approach this court in the circumstance the petition is aggrieved by the non-consideration of his representation.
Much obliged, your lordship.
For admission, item number 5.
Yes, Mr. Mojami. What is this case about?
Lordship, I served for 32 years as workstation for my lordship as a sweeper lordship.
Huh?
The state, they have filed the affidavit and admitted that my service can be considered for regularization in terms of 2015 OM as well as 2025 OM.
So when did you complete?
Lordship, 2022 lordship.
Huh?
In the year 2022 lordship.
You completed?
Yes, lordship. 30 years.
Chalo, only one petitioner.
Only one petitioner lordship.
Okay. Madam, we dispose it up in terms with my earlier orders.
Lordship,
You take 6, preferably within 6 months you complete it.
Lordship,
But the question is, does the regularization will be with effect from the date on which he completes 30 years?
Lordship.
Madam, that day you passed an order for 2 persons. There is only 1 person also. That order, you do it here and dispose of it. You
Lordship, I'll be
completed.
retiring in the month of December lordship. I'll attain 60 years of age in the month of December lordship.
Huh?
I'll retire in the month of December 2025
Hardly matters.
lordship.
I'm giving you the regularization effect from the date on which you have completed 30
Lordship,
years.
lordship.
So that is immaterial.
Yes, Lordship.
Because they may take 6 months, 1 year, that is their lookout.
Lordship,
But
if
you
that
will
is the
get
case-
all payment benefits from the date on which you become
If that is the
regularized.
case. Obliged lordship.
You got that order, na? That day I gave you, that 1 person. You passed another order on 2 persons, but this is 1. Disposed?
I pledge, Lordship.
For admission, item number 6.
Yes, Mr. Jimomi, very fat man. Thick file.
May it please the lordship. Lordship, the state has filed the counter, which was served to me on Saturday.
What is the matter about?
Indigenous inhabitants
The rights
certificate.
of scheduled tribes and human protection in respect to the criteria. Lot of decision. So they have filed a counter
Yes, my lord.
at last.
Yes, at last.
Huh?
They have filed a counter.
So now you want to file a reply?
Yes, my lord. 1 week's time. 1 week's time.
Such a fat matter? Okay. Mr. A. Jimomi, appearing on behalf of the petitioner, submits that the affidavit in opposition has been filed by the state and a copy thereof have been served upon him recently. He therefore submits that submits that some time may be granted for filing the reply. Lists the matter again on 25th of September 2025. In the meantime, liberty given to the petitioner to file the reply by 22nd of
My
September.
lord. Interim orders to continue, my lord,
Interim order passed earlier shall continue.
in both the IA as well as the writ petition.
Interim order passed in the interlocutory application as well as in the writ petition earlier shall continue till the next date.
Much obliged.
For admission, item number 7.
Lordship.
Consideration.
Yes, Lordship. The petitioner stands in serial number 2, Lordship.
So,
Lordship, I don't
just
know.
describe it off, taking in account that number 2,
Lordship,
and they shall follow the office memorandum of 17/9/2015
Lordship,
in letter and spirit and give you the appointment
Lordship,
whenever your
as
chance.
per the list,
Yeah,
whether it's district wise or it's inclusive of all the district.
under
Because
compassionate
as
demand.
per Office Memorandum 7, December 2016,
Hmm?
only the indigenous inhabitants can be appointed under grade 4 posts.
This has been done as per the PNR AR 2019.
Yes, Lordship.
What does it say that PNR? You have the blocking? 9(4), yeah. In continuation, in insertion, compassionate made under post shall be strictly in order of date of death, and first preference shall be given against those who have died earlier and who fulfills all the eligibility criteria. So, date of death. So you will get the first preference. Huh? Isn't it?
No, Lordship. Lordship, as of now, there's no vacancy, Lordship. As of now, there's no vacancy, Lordship. So,
Date of death?
as per the addendum.
Oh,
Lordship.
okay.
Mm.
You'll get the second preference.
No,
Your father died in
Yes, sir.
2024.
But my only question is whether this list was prepared,
Hmm.
whether it's inclusive of all the district or it's for a particular district.
Where is Khar village? You are Mejifema town.
Yes,
It's
Lordship.
under Chumukidima district.
So-
It comes under Chumukidima district.
And Khar?
Mokchong.
So here does it say that it will be different way? Appointment on compassionate basis shall be given to only those so and so. Appointment of years shall be only on regular basis or recruitment, and if only if regular and meant for the purpose are available in the department where the deceased employee was serviced. Applicants shall have only regular vacancies meant for that purpose are available in the department where the deceased employees were serving. Department. You mean to say as per,
Lordship, as per Office Memorandum 7 December 2016, all vacancies arose in grade 4 posts will be given
which
only.
office memorandum? You have not enclosed that.
Para 4.
All direct recruit vacancies in grade 4 post in district offices of the department shall be filled up by indigenous inhabitants of the respective district in making recruitment of AR. Now, this is not for compassionate appointment. This has nothing to do with compassionate appointment.
No, however, even if under compassionate also, I cannot be appointed in another district.
Huh? No. How do you bring this? Unless these are brought within these terms.
Now, what I want to say is, if the respondent authority can maintain the seniority list as per the district wise.
But how do you bring the office memorandum of 7/12/2016 to 17/9/2015? Not possible.
No possible.
This is for other people. Because you see, compassionate appointment is a scheme, it's a policy of the government. Normally, that is a case which is outside the purview of Article 14 and 16.
Mm.
And this is therefore given as a to tide out the difficulties, immediate necessity. But here in Nagaland, they have done one thing. We are going to give them first person who died first, we are giving this opportunity first, and this is how we are going maintaining a serial number. Now here it says that you are at serial number
2.
2. Madam, against vacancy caused by any MTS post means why? Madam, I don't understand why here only in the case of the petitioner you have put the petitioner's father.
Lordship, as per the as per the compassionate appointment, Lordship, there are certain lists for the compassionate. So as per the list, Lordship, here the petitioner stands in serial number 2, Lordship.
No, that I understand. Against vacancy caused by. Now, why petitioner is against his father's vacancy and rest are against any MTS post? See, against vacancy caused by any MTS post, any MTS post, any MTS post, but in respect to the petitioner, his father.
So vacancy has already arose after the demise of my late father.
Hmm?
Vacancy is still, whether respondent have fill up the vacancy or not in my
But
vacancy
it
arose.
has to go according to the seniority list, Lordship.
Now, understood,
Yes, Lordship.
but then why the others are against any MTS post? All five, amongst the 5,
Yes,
all 4 are against any MTS post, but in respect to this, only the petitioner is as regards this.
Mm.
Because if we see number 3,
Yes, Lordship.
appointment can only be in that department where the father was working, and it cannot be in respect to any other department,
Any other districts?
isn't it?
Yes, Lordship.
So, and here it says may be made to the post falling under the combined recruitment year. The ceiling for compassionate appointment of 5% of the direct recruitment vacancies in Group C and Group D have been done away with, the provided such appointments does not exceed 50% of the vacancies during a year. The appointment against post for direct recruitment in Group C shall be by way of shall be in entry grade only. For the appointment to any post for direct recruitment in Group C shall be limited to those posts outside the the date of the appointment and their interpolation with the different recruits shall be made in the upper age limit of the applicant under the scheme may be relaxed by so and so. But Mr. Counsel, how do I direct? I can only ask them to consider.
Not sure.
You are on the subject matter of consideration.
Not sure.
Then what remains? We'll put it that only. They will
Yes, Lordship.
consider and appoint you
Yes.
whenever your chance comes.
Not sure.
Yes, Lordship.
There's no, I cannot direct them to give him appointment. He has a right. You are considering it, and you will consider and give it at the time when his chance comes.
Yes, Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. Eschem, the learned counsel appearing on behalf of the respondents.
1 to 4, Lordship.
1 to 4.
Lordship.
Good stop. The case of the petitioner herein is that the petitioner is aggrieved by the inaction on the part of the respondent authorities in not appointing the petitioner on compassionate, as per the compassionate scheme of the government dated 17/9/2015. The facts as would be available from the materials on record show that the father of the petitioner, late in Namtusai paragraph 3, Rulo, K. Rulo, was appointed as a diary attendant by an order dated 28/7/2006, passed by the Director of Agriculture under the establishment of the Principal, IETC, Mezifema, Nagaland. The father of the petitioner expired on 13/4/2024, leaving behind 5 dependents.
Lordship.
First, the petitioner had applied for appointment on compassionate or humanitarian grounds by filing an application on 18/4/2024 against the vacancy claimed invalid. And the same was forwarded by the respondent number 4 to the appropriate authority. The grievance of the petitioner herein that the said application have not yet been considered, and as such the present writ petition has been filed. This court, by an order dated 29/7/2025, had issued notice. First, the matter came up before this court on 28/8/2025, and this court had asked Miss S. Chand, the learned government advocate appearing on behalf of the respondents, to obtain instruction as to whether the petitioner's case is under consideration before the respondent authorities for appointment on compassionate basis. Today, when the matter is being taken up, Ms. S. Young places before this court a chronological list of applicants applying for MTS post under the compassionate ground in the Department of Agriculture
Lordship.
of the government of Nagaland. The said list, being relevant, is kept on record and marked with the letter X. From a perusal of the said list, it appears that the petitioner's name is under consideration and is at serial number 2, taking into account that the petitioner's father expired on 13/4/2024 and the father of the person at serial number 1 expired on 2/3/2022. First, taking into account that the petitioner's case is under consideration. First, this court, therefore, disposes of the instant writ petition, thereby directing the respondent authorities to consider the case of the petitioner strictly in terms with the notification dated 17/9/2015, read with the notification dated, office memorandum dated, read with the notification dated 9/4/2019. First, with the above directions, observations, and directions, and full stop. With the above directions, observations, and directions, the petition stands silent.
Much obliged. Lordship.
Obliged.
For admission, item number 8.
A copy of the instant order be served upon the respondent number 4 for due compliance.
Much obliged. Lordship.
A certified copy, huh?
Lordship.
Next,
Yes, Lordship.
you.
Lordship.
Huh? Tell me. Oh, no salary from March 2021.
Yes, Lordship.
Yes, Your Lordship, as per the last court's order, I have instructions, Your Lordship.
Madam,
Yes, your lordship.
these petitioners are minor clerical mistakes.
Yes, your lordship.
Even the Supreme Court says when there is an irregular appointment also, that can be regularized. Here, it is not a case that there is some major mistake or there is some bogus elements brought in. As per your instructions, it is minor. Kindly come,
Yes, your lordship.
R1,
Yes, your lordship.
the petitioner are R1, are under R1 category. As such, until their cases have been conveyed, means R1 are those who are having minor. Isn't it?
Yes, your lordship.
Employees who have minor clerical mistake in their documents are under R1.
Yes, your lordship.
Those employees who have several errors in their documents are category R2. And N category are doubtful, bogus, and contain multiple. So he have minor.
Your lordship, I would also like
And
to.
this happened when? 2023. When did you find out that it is minor? And he has not got his salary from 2021.
Your lordship, the latest documents
Name to
was.
be corrected in PIMSS. Let us see what are the grounds.
Your lordship,
This is the blue ones, no?
yes, your lordship. I have flagged it and the petitioner's name are at serial number 96.
Let me rise for 10 minutes
Yes, your lordship.
and ask the registry to give me a magnifying glass also. Seeing that it is so tiny in the meantime. And then get a magnifying or make it bigger. No, you can't see anything. Name is to be corrected in so and so as per application order 2 and D be corrected in Iman as per Aadhaar personal file. Name of the father's name to be corrected in Iman as per application. These are two minor mistakes. You can't stop them from getting salary.
Your lordship,
Have you intimated them? If the name is to be corrected, and whose mistake it is? If you have not intimated them, means it is not their mistake.
your lordship,
Somebody must have made some mistake.
we have intimated them.
We do one
That's-
thing.
Yes, your lordship.
We ask you to file an affidavit containing the names of those persons who were responsible for making wrong entry, and thereupon to deduct and direct you also to pay them the salary along with interest from 2021 at the rate of 18%, and that interest of 18% shall be borne by those persons.
Your lordship, I would also draw your attention to this, your lordship. Here, as far as the correction is concerned, your lordship, this is with regard to name as well,
You see, the
with
name
regard to.
and father's name to be corrected in PIMS
Because-
as per application order. Name and father's name to be corrected in Aadhaar as applicant order. Date of birth to be corrected in PIMS as per Aadhaar. So, have you intimated the petitioner?
Yes, your lordship. And that's how the petitioner will submit those documents, your lordship.
Now, when did you intimate the petitioner?
Your lordship, as far as that is concerned, I have no information, but
No,
because
you-
these documents are with the petitioners, your
Okay.
lordship. So when there is discrepancy in.
We'll have it
Aadhaar
tomorrow
and-
and get the names of those officers also who were supposed to intimate. This is not done, madam. See, name, father's name, have you been intimated, Mr. Counsel? No.
No.
Then who is going to do this? Madam, only instruction required is who is going to do this correction? And if it is the petitioner, have you intimated the petitioner? I put it on the order. Short order, you get it. We'll take it up on Wednesday. Get this thing.
Your lordship on Thursday, your lordship.
On
Oral,
Thursday,
oral
the
instructions, oral instructions. On Thursday,
Oral, no, only written instructions.
then on Thursday, your lordship.
No, read it.
And your lordship, before, your
I'm
lordship,
not, I'm asking you two things. One is, these are corrections. Who is to correct?
it's the
And if it is
PNR.
the petitioner, have you intimated the petitioner? That two words. Full stop. The heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. So-and-so appears on behalf of the respondents. The petitioners herein are aggrieved that from the month of March 2021, they have not been paid their salaries. Pursuant to an order passed by this court on 26/8/2025, instructions have been placed by Ms. So-and-so appearing on behalf of the state respondents, wherein an instruction dated 28/8/2025 has been placed before this court. The said instructions are kept on record and marked with the letter X. From a perusal of the said instruction, it appears that there are certain verifications being carried out by the respondent authorities. First, while carrying out the verification, the respondent authorities have categorized the work charge employees into 4 categories. Category A are those employees who have no discrepancies in their service records. Category R1 are those employees who have very minor clerical mistakes in their documents. Category R2 are those employees who have several errors in their documents. And category N are those employees who are doubtful, bogus, and contain multiple mistakes in their service records. It is an admitted fact that the petitioners herein fall within the category R1, which means their service records have minor discrepancies, minor mistakes, minor clerical mistakes. This goes further. It further appears that from that in the said instructions so placed, there is a communication issued by the engineer in charge NPWD to the secretary on 29th of September 2022, which is almost 3 years back, wherein certain discrepancies have been brought in respect to the minor discrepancies, clerical error, mistakes of all the R1 category work charge employees have been forwarded. From the said, it appears that there are certain clerical mistakes as regards the father's name not matching with the service records. This court therefore inquires with the learned counsel appearing on behalf of the respondents as to who is required to correct these clerical mistakes. And if it is the petitioners, if it is the R1 category work charge employees, have those work charge employees been informed? And if it is and have those work charge employees, and more particularly the petitioner, being informed about the requirement to make those correction of those clerical mistakes, minor clerical mistakes. List the matter on 3.9.
Oblige.
For admission, item number 9.
Revelation, Lordship. I'm for state respondent, respondent number 1 to 4.
No,
Lordship
this
here.
is Gauhati High Court.
Yes,
Yes, Lord.
Yes, what is it? This matter will only come to me only, wherever I go. What are you asking for?
As per the last order, it was to be listed after 4 weeks, but then I believe in view of the order number 3 issued by the Honorable Chief Justice, this matter has been placed before your lordships.
This is for creation of post.
Yes, Lordship, for effective functioning of the High Court, we need to have adequate number of staff.
Hmm.
This is the only High Court in the country where there is no court master. Lordship is well aware, we have 3 courts. Normally, of course, regular courts is 2 courts, and it is to be manned by a court master under the initiative of a court master, but we don't have even a single court master in this bench. And the bench assistants are made to discharge the duties of the court master also. And they are compelled to work excessive works, extra time. In
Mr.
para-
Ramir,
Lordship.
can this be taken up in the infrastructure bench? This matter can be taken up because I'm also heading that bench also. Infrastructure bench, because here is a case that this appears to be not a service condition, but it is for creation of post.
Creation of posts, yes.
So I think this matter be placed before the infrastructure bench because that matter I'm taking up with my brother Justice Arun Dev Chaudhary. We are heading that bench. So this matter is being taken up in that bench should be better. Yeah? Although it is taken up through the, it will be done through the video conference
Lord,
mode.
that can be done.
And, you have, I think it is fixed on 18/9. I have a bench out there of this matter.
Lordship.
So let this be placed before the infrastructure bench.
Lordship, that can be done.
Yeah, because that would be, because I'm taking up there also as regards the completion of the building. That is also another aspect. But I think there is a good chance of being completed very soon. What do you say, Mr. Jimumi?
Yes, sir. That's fine, ma'am.
That is because this would not strictly fall within the ambit of the
Service matter.
ambit of the
Conditions of service.
nothing to do with the conditions of service. The inaction of the respondent authorities in creating, in creation of the post, despite the administrative approval given by the Chief Justice given by the Honorable Chief Justice of the Gauhati High Court is the subject matter of the present litigation. Mr. C.T. Jameen, the learned senior counsel, appearing on behalf of the petitioners. How are the petitioners agreed?
They are made to work extra time. And they are also due for promotion, but stagnation is also there. And they are supposed to discharge whatever they are supposed to discharge. But then they are assigned extra works, which they are not supposed to discharge also. For example, as I have cited with regard to the court master, they are pinch assistants only. But then they are assigned the duties and responsibilities of a court master. Just had a injustice meted out to the petitioners.
So they are bench assistant, but they have been asked to
Judicial
do,
assistants.
they are judicial assistant.
Yes.
They have been asked to do work of a bench assistant,
Court master also.
court master. The court masters out
Actually,
here,
we should have at least 2 court masters, since 2 courts are regularly sitting. But then there is no court master, in spite of the fact that the Honorable Chief Justice has approved for creation of the fourth.
taking into first of this court further takes note of that notice was issued by this court on 19/8/2025. Asking the respondents to bring on record their stand by filing the affidavit. However, the affidavit have not been filed. Mr. Imti Song, the learned AAG, submits that a period of 4 weeks is yet to be over, and as such, the respondents would be filing the affidavit. The issue involved, as stated above, is an issue coming within the ambit of the infrastructure bench, so constituted by the Honorable Chief Justice of the Gauhati High Court. Taking into account the above, the registry is directed to place this matter before the infrastructure bench of the Gauhati High Court. Footstep. In the meantime, the respondent state shall bring on record their stand by filing the affidavit on or before 15th of September 2025.
Worship. Your Worship, my presence may also be shown.
Huh?
My presence may also be
Yes,
shown.
yes, sir. Mr. My orders are, I don't say anything on top of it, all the names are
Very
given.
well. Much
Mr.
obliged.
A. Jimomi, the learned counsel, standing counsel of the Gauhati High Court, Kohima bench, appears and submits that with the new building, the new High Court building, which is coming up, without the creation of this post, it would be difficult to man the said building, as the court infrastructure. So they can list the matter on so. But Mr. Jimu, you have to appear through video conferencing on that day.
I'll do that now.
Hmm?
For orders, item number 10.
Where's the report? Mr. Thangton? Report on threatening and ultimatum received served to the initial public interest.
My lord, I filed my affidavit on 26th.
Ah, I've seen it. 21/8.
Yes, yes.
You are appearing for whom, Mr. Jimumi?
I'm for the petitioners, ma'am.
Who is the petitioner?
The Molbom village,
Ah,
the Molbom village council.
now what has happened? What is
Now-
the issue involved?
Your Lordship, Molbom village is in the Chumugnuma district. In the year 1995, 1990s, earlier, Your Lordship will recall, there was a huge conflict against the Kukis, directed against the Kuki tribe. So in that scenario, two Kuki tribesmen, they were allegedly killed somewhere in Manipur. The Angami Students Union, they issued a quit notice to the Kuki tribe because of what happened there in Manipur. The entire Kukis in the state of Nagaland were directed to vacate. In that scenario, we were forced to make an undertaking. We were forced to execute a declaration saying that we are subservient to certain villages. Based on that, actions has now been taken against
So
us.
the people who are living in this village,
My lord,
what tribe are those?
Kukis. And the other tribes, the Mezipema is the Angami tribe. So, developmental projects have come into the picture. The railway line from Rangapahar up to Zubza. Issues began there. The Nagagi incubation city, which apparently some portion of Molbom village land is also going to be taken. Mezipema village wants to take their compensation. Mezipema village wants to change the name of Molbom village to Mezipema village. It wants to change the name of Molbom village, Molbom station, which is there in the Molbom village land, to Mezipema station. And we are being forced to accept that. That is why I'm here before this Honorable Court. When the petition was moved, an interim order was granted by this Honorable Court saying that during the pendency of the case, the lives and properties of Molbom villagers should be protected by the state response. As soon as that order was passed, a blockade was imposed on us. Our villagers were restrained from going into Mezipema to sell our farm produce. We were restrained from exiting the boundary of our village. School students were not permitted to go to school. 16 families residing in Mezipema village, Mezipema town were evicted. That is the case. We filed FIRs, no action taken. We filed complaints to the Deputy Commissioner, no action taken. That is why we are before this Honorable Court. So when these things happen, Your Lordship, after the interim order was passed, there were two courses open to me. Either file an application seeking strict measures, praying for strict measures by this Honorable Court, or file an additional affidavit placing all this in record and praying before this Honorable Court that a report may be called for. We should probably prompt them into action. Some action has been taken. Some action has been taken. But even on the day when the order was passed, until we filed a complaint again, until the order was brought to the notice of this Honorable Court, nothing was done. What has after that interim order, Your Lordship, again, I would have filed another additional affidavit, of course, with Your Lordship's leave. But after the interim order, again, further developments have taken place. Can I place this before Your Lordship? And in the affidavit of the containing the report, there is a statement that even the Mezipama villagers, they have taken steps to comply and normalcy will be restored. But what they have not enclosed, Your Lordship, very interestingly, is a letter in question written by the respondent number 7.
Which document you are referring?
I'll come to that, Your Lordship. No. Wait. Yeah, page 6. Page 6. Page 6. Type copies at page 6. The original is at page 5. Has your lordship got it? This is by the Mezipima Village Youth Organization. This is dated 21/8/2025. And this is addressed to the Additional Deputy Commissioner Mezipima, submission of representation. The type copy, may I take your lordship to the type copy? A threat, your lordship. A threat. So if anything happens, to Molmon village, when they are in Mezipima town, they will not be responsible. If the state doesn't take action to redress their grievances.
Yes, why the state is not being in a position to take up the case?
May it please my lord. I may be allowed to read my affidavit, compliance affidavit. Page 2, paragraph 3. May I read my lord? That the deponent at the outset begs to state that prior to the receipt of the Honorable Court's order dated 21st August 2025, the deponent was in receipt
You are
of the writ
reading to
petition
which affidavit?
of my,
Filed on 21st August.
no, my lord, filed on 26th of my report from the Deputy Commissioner, Chumukitima, the respondent number 4. As directed by this Honorable Court on 21st August 2022. my lord.
Okay, got it. Paragraph 3.
That the deponent at the outset begs to state that prior to the receipt of the Honorable Court's order dated 21st August 2025, the deponent was in receipt of the writ petition number 129/2025, Molmon Village Council and another versus State of Nagaland and 9 others. And the same was forwarded to Additional Deputy Commissioner Mezipima with the direction to ensure that the lives and properties of the petitioners are protected. My lord, may kindly come to running page 9. May I read, my lord? Current situation. 1. The highway remains open. There are no youth/villagers stationed on the route. Free movement of traffic has been restored. Number 2, the law and order situation is under control and no unwanted incident has been reported so far. 3, however, reports indicate that families from Molmon village residing in Mezipima town have been displaced. Students from Molmon village pursuing studies in Mezipima town have been affected. Their list of displaced is awaited from Molmon Village Council. Number 4, in the interim, the DEO has recommended
What is DEO?
District Education Officer has recommended online classes for the affected student until the situation stabilizes. Further, the DEO has been instructed to explore other means of accommodating the affected students. Number 5, as part of peace outreach, this office has engaged with community leaders, church representatives, and public organizations to help diffuse tensions and encourage dialogue between the two villages. A few community leaders have been actively working under the request of this office to usher in peace and foster reconciliation. Continued involvement of these stakeholders is expected to play a vital role in sustaining calm and preventing further escalation. Sentiment on the ground. One, tension between the two villages remains sensitive, though contained at the moment. Two, Mazipima Village Council has expressed conditional cooperation, while Molbon Village Council has raised grievances on displacement and student safety. Challenges. One, resentment among sections of villagers may pose a risk of renewed confrontation if not continuously monitored. Two, there is apprehension that the conflict between the two villages may escalate into a tribal issue involving the broader tribal communities. Three, the possibility of involvement of underground
that
slush.
arises on
Yes,
account of two issues. One, as regards the change of the railway station name.
Yes,
Or the
ma'am.
name of the railway station.
Yes, ma'am.
And the second is who is entitled to compensation.
Change of the village also, Your Worship. Name of the village also.
How can a change of a village name take place without the concurrence of the
Yes.
state?
Yes, my lord.
And because the change of a village can only happen with the home department,
Yes.
because change of a city, a change of the name of a city, everything happens with the concurrence of the
Ministry of Home.
union,
Yes.
home department.
Yes, please.
Here also, if it is a change of the name of a village, it has to be done with the concurrence of the state government.
Yes, ma'am.
Even the Ministry of Home, Your Lordship, they are sending instructions to that effect. Even for a name, change of the name of a village, town, city, etc. Ministry at the center, not just the state. They are sending instructions on that.
No, I don't think Ministry
Yes.
of Home has any relation
Ah,
with the change of the name.
Yes, Your Lordship, I have enclosed that in the notification in my
Where?
writ petition. Page number.
Which document?
Page number.
Page?
Lordship, give me a few minutes, Your Lordship.
Hmm?
Make notes on that. Your Lordship, at page 206 is a typed copy.
206.
Yes, and the original is at page 204, section 45. Take a note of this, okay?
This is an executive instruction
My lord,
by which the governor have put the AI on the home, Ministry of Home. But normally, when it comes about the change of the state, name of a city, then it is with the Ministry of Home.
my lord.
Now,
Lordship,
how therefore, where's the ministry, any union party?
yes, my lord, union is a party.
Who is the union appearing for? No. Because therefore, without the concurrence of the home department, there cannot be a change of the name.
Yes, ma'am.
One. Then the question relates to as to whether the station should be named in this. Then again, the union comes in.
Yes, my lord.
The railway station. I think the union
ma'am.
ministry has to be involved. They are the person concerned who will put the name.
Yes.
As regards the compensation in respect to 330 hectares of land.
Not the entire land, Your Lordship, there are other villages also involved.
Anyways, any compensation out there can only be decided by those authorities.
My lord. My lord.
So these are things which has to be either done by the Ministry of Home or the railway ministry
No, no.
as regards putting the name.
No.
No, neither any person, any group or tribe can ask that put my name or their name,
My lord.
isn't it? What do you say, Mr. Jamil? You are appearing for the respondents?
I'm appearing for respondent number 7, Lordship.
It's the private respondents.
Yes, Lordship. Today is fixed for submission of report and filing of affidavit by the Deputy Commissioner Chimakitima. And so far as the main case is concerned, it is fixed to be listed up to 3 weeks. And meantime, we have to file affidavit. Now, so far as the prayer of the petitioner is concerned, there are 2 prayers, mainly A and P. In prayer A, they have sought for quashing the 2 orders. That is, one is sending a letter by the additional deputy commissioner to deputy commissioner, making a proposal, suggestion that it would be good if it is changed to so and so. That is a suggestion. Whether a writ will lie against a suggestion given by one officer to another officer when no order has been passed. That issue will also be there because it is only a suggestion. By raising the ambient order, Lordship will see. And the other ground is yes. Notification, a notice was issued by the Deputy Commissioner calling the affected parties, calling the parties from whom the land has been acquired and to pay the compensation. For the purpose of paying the compensation, notice was issued. All others came and taken the compensation. It is the petitioner who has not come forward to take the compensation. And if we look at the entire petition, the petition is just a khichdi, mixing so many things together. Whether a writ will lie, that issue will be very important. Because in the second part of the prayers.
Therefore, I say, therefore, the grievance are threefold. The first is as regards the change of the name.
Lordship.
The change of the name can only happen through the Home Department of the Government of India. And more so when, by way of a notification of 1998, it has been placed by the governor. So unless the home comes and gives a response, there cannot be a change of the name.
Yes.
Putting the railway station name also is dependent upon the railway ministry.
Lordship.
So that is another thing. As regards the compensation, if a person is agreed with the compensation, then he can, this is done under the Nagaland thing.
No. Reference is made to the Land Acquisition Act, but no procedures followed.
Huh?
No procedures followed. Just by using the Land Acquisition Act, some amount has been ordered as compensation. No award has been passed, no acquisition proceedings have been registered.
So therefore, if you see by the Nagaland Requisition and Acquisition Act, the acquisition is made under Section 6, if I'm not wrong.
Yes.
And then with Section 9, read with Section 9. And by legislatively, they have incorporated the provisions of the Land Acquisition
Yes.
Act 1894. If that be so, this would come when the Deputy Commissioner is calling both persons. It would come within the ambit of Section 9, an inquiry being made under
Yes.
the Section 9 of the Land Acquisition Act 1894. And he is then to say who is to get the money.
Yes,
He may pass an award.
yes.
And if somebody is aggrieved or somebody makes a claim, then again, in view of Section 12 they can, and 11.5, they can very well incorporate Section 30 of the Land Acquisition Act and send it to the court, where the
Yes.
court will decide everything and the
Yes.
money will be paid there. And whatever, how it is to be done. So these are the 3 aspects which can be very well taken outside the purview of the writ petition. But the most important thing is as regards the life and property of
Yes.
the citizens, which needs to be protected by the state, as the state has the resources to protect.
Yes.
So the only writ petition, the only cause for the writ petition seems to be as regards the protection of the life and property of the
Correct.
citizens,
Yes.
which Mr. Jamil also would not mind protection being given to both
By
the
the
sides
state.
by the state.
Yes,
So that is the only scope.
yes.
Remaining all will be done as regards the name should have been there or not. There are certain, I think, I remember there was one case, the Union of India has certain guidelines
Yes,
by which how the name would be there. And how a challenge to the name can also happen is by way of a suit. Not by way of, because this is a question of evidence as to how the name should have been. Now, what has Election Commission of India has also done is another aspect, how they have put these names. These are many aspects which.
In fact, Your Lordship, the criteria is there in 207. How and on what basis name is to be changed? It is there in 207. That copy.
Unless there is a very special, it is not desired to change. The name of the year have a historical, it should not be
Yes.
changed, but a change should not be made merely on the ground on local petroleum selecting new names case has been here. No, this is not, this is the government of Nagaland,
Yes, my lord.
but the Ministry of Home Affairs also has.
Yes.
Because I remember while reading out how they changed the name to Prayagraj from Allahabad.
Yes, yes.
So these are things which was given out there.
Prayagraj.
Now you have many places like Calcutta,
Yes.
or it became Kolkata. These are
Chennai,
names how
Mumbai.
it has been changed only by the Ministry of Home Affairs. So these are done by the government
Yes, ma'am.
of Nagaland, but there are circulars by which the Ministry of Home Affairs. The most important lawyer would be Mr. Yangavati.
That insofar as the acquisition process is concerned, Your Lordship, there has been no acquisition. It is just an arbitrary assessment. And a notice whereby so-called landowners have come with call to take compensation. That's all.
So no, see the award is being made. The people have been invited, the award has been made.
No award. There is no award, my
No
lord.
award?
No award.
Lordship, they were called, but they have challenged
No,
that,
no, no,
the
no, no. This
notice.
is a very wrong statement, Your Lordship. There is no award.
We will
This
file
is-
detailed
This is
affidavit
in fact the
supported by document.
which is squarely attributable to him.
Anyway, the award is there or not would be, the best person will be Mr. Sankam Singh.
My lord, I'm yet to receive instructions.
In fact, if a specific direction can be given to him to produce the award, there is no award.
The person who doesn't come to take the award, definitely there will be no award. But for the persons who come forward, they have
Let him
already
produce it.
received.
Let him
State
produce.
will produce, I will also produce.
There is no award, my lord. This is a very wrong statement.
Award, have you, Mr. Jamil, have your persons received the amount? Any compensation?
Whoever come forward, they receive the compensation.
Have your client got the compensation?
No, I'm village council.
Huh?
So individuals, they have received.
They have received.
I am the village council.
So possession must have been taken.
No,
Yes.
my lord. Not in my portion. Not in my portion.
So you are still in possession.
He is the only person left.
No, I am saying, Your Lordship, acquisition is for public purpose. I don't mind. But in terms of the procedure prescribed by law, not in this arbitrary manner, Your Lordship.
And what provision has been violated?
But Mr. Zimbabwe, the saddest part of life is the 1965 Act, which
My
was
lord.
drawn in lines with the Assam Acquisition and Requisition Act
My lord.
1964. On the face of it, so it means everything is given a go by.
My lord.
By way of a notification issued under Section 3, requisition is done.
My lord.
Section 6, the moment they issue a notification under Section 6,
My lord.
the land vests
My lord.
by operation of law.
That part is all right, Your Lordship. That part is
Without
all right.
even taking possession, land vests.
That's all right, my lord.
But the problem arises with, as per the new act or even the Land Acquisition Act 1894,
My lord.
the land cannot vest
My lord.
unless award is passed or if
lord.
prior to that some amount is being paid
My lord.
under Section 17. But that has not been done.
No, it
So
has not
that
been
is
done.
the main problem
My
here.
lord. There will be none.
65 Act does not postulate
My
the
lord.
requirement of anything to that effect, that earlier payment has to be made and all these things. These are not absolutely absent.
My lord.
They still continue to, because in 1984, there has been an amendment to the Land Acquisition Act.
My lord.
But this has not been incorporated out here in the 64 Act or
65 Act. But after that, Your Lordship is aware that we have an act called the Nagaland Town and Country Planning Act. Now, in the Nagaland Town and Country Planning Act, that act specifically states that for the purposes of acquisition, the 1894 Act will apply. In total.
That is a subsequent act.
Yes, my lord. A lot of factors are here, Your Lordship. It's not as simple as another friend wishes to make it out.
But the fact remains that wouldn't it come within the ambit of a
Yes.
disjoinder of causes of action? Much of many causes of action.
It does, my lord. And that was the query which was put to me when I first moved the petition. But everything is linked to Molvom village land. Everything is linked to Molvom village land. My name, they want to change the name of my village. They have already changed it in official records, Your Lordship. It is already Mazipama village. Already changed.
When?
Recently, Your Lordship, I have included us all in my writ petition.
Means without following the.
Without following the procedure, without my consent.
That is not correct, Lordship.
Oh, it
Let
is
them come
Look
with
at
a
smoothness,
specific
Your Lordship.
date. They will
So
file on line.
let's do one thing. We have this matter on some other day, ask them to file the affidavits.
Yes, my lord.
And then in the meantime, the interim order which continues shall continue. And the state of Nagaland, including the Home Commissioner and all, shall strictly look into it that there is no violence or anything, and people's life and property is not disturbed.
That is one point, Your Lordship.
Going by the.
And I have filed FIRs, but no action is being taken on my FIRs.
Going by the
Now,
affidavit
what
of
we
the
have
Deputy
here is-
Commissioner,
About 50 plus school going students. They are scarred for life. They fear for their lives. And the other side is going about doing its work with impunity. How do we restore the fate
I
of
understand
these young
that,
students, Your
but
Lordship?
the fact remains that the affidavit which have been filed on 26/8 also mentions that the school students have been affected.
My lord.
These are facts which are admitted by the respondent
Yes, ma'am.
authorities, respondent DC. But the fact also remains that it is a constitutional duty imposed upon the state
My lord.
to protect the life, liberty and property of the person
Yes, ma'am.
in accordance with law.
Yes, ma'am.
So when it is their responsibility, it is for them to look into it. Yes, there might be certain infractions which are there, so they have to look into these aspects.
That is true, my lord.
So therefore, the interim order which has been passed has to be continued. And further, there should be specific direction even to the Home Commissioner. He's a party.
Yes, my lord. He is the party.
To take appropriate action so that the problems which have been mentioned by the respondent, by the DC in the affidavit can be solved. Because you see, there are one aspect, the court can pass certain orders, but the fact that on the ground there needs to be
You have to.
a action taken on both on the political side also. How the political side would look into
Yes.
and take a decision is another various infer. These are within the realms of the executive.
My lord.
So I think that should be in the meantime, let them file their.
Very well,
affidavits.
till then status quo be maintained because going by the affidavit of the additional Deputy Commissioner, Chemakitima, I think the situation is under control. So let the status quo may be maintained.
Status quo means what, my lord? 16 families already displaced. School children not going to
Lordship,
school. That is what he wants.
My learned friend is focusing in that. Lordship here, even the affidavit of the Deputy Commissioner says that law and order, it is very sensitive. Now, displacement of 16 families, who knows?
No,
Some-
the Deputy Commissioner has also admitted
Yes.
Yes. That is because of the fact that the village authority, without the knowledge of the village authority, some move.
Hmm.
If they do anything, It is for the safety of the 16 families that they may have displaced. Otherwise, anytime anything may happen, we don't know. And the authorities may not also know that. And if something happened, then risk element is also there. So for the safety of everyone, that perhaps must be the best possible option. Lordship is well aware, law notary is such a very sensitive issue. Lordship is aware what has happened in Manipur. One order was passed, and then till today, the problem still exists. Those are the problems, Lordship. And the affidavit of the Deputy Commissioner has clearly
Mr. Jamil,
mentioned.
I understand that. That is why I say these are things which are to be resolved by the executive. These are things which will require a political solution.
Lordship.
So it is, but the fact that the rule of law also has to prevail. The rule of law means that it is a responsibility or a constitutional obligation of the state to protect the life, liberty, and property of a citizen
Yes.
if they are in distress.
Yes.
So therefore, the order, this court would not say that do this, do that. No. The court will say the state has to protect them.
Yes, Lordship.
It is not that they can do anything or you can do anything,
Yes.
but it is the rule of law has to be maintained.
Yes.
I'm not saying that whether this should be, because if it is, the name has changed from, what is the name, from Molobon to
Malbon
Mezima or Merizima. That you
Mezima.
have that, Merizima is the place where you have that particular
Pineapples, where we get plenty of pineapples.
pineapples or the animals. There's
That is
some
Jharna Pani.
CSIR.
ICR, that is Jharna
That is
Pani. Your Lordship.
Jharna-Pani.
That is Jharna
Just
Pani.
above that, after crossing that,
township-
it's
the township-
Metsefima.
The township just before reaching that, while going down from Kohima,
Ah.
that is Mezipama.
So that place, so whether the name should have been this or that, it is, I think the Home Department has to take up on. Let us hear why no union person is appearing. We'll take it up at 2. Both of you kindly ask either of the central government council to be present,
Lordship.
because their presence is required
Yes.
for passing appropriate order. Because earlier, somebody was appearing for the railways also. In one matter, in your matter,
Mr. Gupta, Your Lordship.
Mr. Gupta, he's a railway council.
He's central government council as he is entrusted with railway
Get
matters.
hold of him and we'll get him.
Probably he has left, Your Lordship.
Asking to be there in the video. So do and things so that I can pass an order in his presence, asking him to bring on affidavit, as well as the central government to bring an affidavit as regards the name change.
Very well.
Because they would be the best person to say. Because more particularly in the view of this notification. As regards the compensation, whether the award has been passed, we'll ask them to file an
Yes,
affidavit.
yes, Your Lordship. Yes.
And apart from that, the interim order has to be extended.
Yes, madam.
And keeping the duty upon the state to take the law and order
Why not?
situation into that. I'll come back at 2.
Very well, madam.
Mr. Jamir have said something as regards Manipur, so that is why I'll take a lunch and then think over.
May I please, Your Lordship. Your Lordship, may be pleased to mention hearing item 11 and 12. Your Lordship, here I'm yet to get instruction. So if it can be posted on Tri-Stay, Your Lordship. Ansari Ali, Your Lordship, 11 and 12.
Thursday is the last day.
Then Wednesday,
Wednesday, I've got so many matters.
but Thursday it can be closed. I'm positive that it can be closed, Your Lordship. On the
No, I'll
instruction.
pass an order,
Mm.
which I was thought about, that I will say that there have been certain procedural violations.
Mm.
But taking into account that the amount of 5 lakhs has already been awarded by another.
Your Lordship, it was not ever, you just like recommended only, Your Lordship. It cannot be, it is not binding also, Your Lordship, as you are well aware, Your Lordship.
Hmm?
It is just a recommending only, Your Lordship. It is not finalized, Your Lordship. If you can
Then-
see the contents, Your
Then
Lordship.
I will put a stamp of authority on that and say that you pay 5 lakhs. Thing is, otherwise 5 lakhs has been thought to be good by NHRC, National Human Rights Commission. So therefore it's good. And if they don't pay, you are thinking about that, okay, we are not going to abide by what the National Human Rights Commission says, then
No, no,
obviously then.
Your Lordship,
I-
it's not
I
like
will
that.
Put it as a, as per.
Your Lordship, what I mean is that if it is not being finalized, Your Lordship, on the outcome on Tri-Stay, Your Lordship, then Your Lordship, there's already an alternative that this court looking into it can pass, Your Lordship, accordingly. So it can be posted on Tri-Stay and Yeah. much obliged.
Yes, Mr. Ingomati. You are the person who is, who
Sir,
who
Gupta is
have
also here.
intervened for the Ministry of Home as well as the railways.
This will be for the railway, Lordship.
Hmm?
It will be for the railways, Doctor.
Your Honor, actually, all the CGC, they have entrusted with the railway cases.
So now the question is, there are three things.
So,
First is changing of a name of a village. They say that the village
Molvom.
name was
Molvom.
Molvom. They want to change it to the another name, Mezifama or something. Now, the procedure which is given is the state government recommends, and then the Ministry of Home Affairs looks into if it is as per the guidelines, and then puts the approval. And then it is notified. That is one. So the Ministry of Home's affidavit would be required in that regard as to whether any proposal has been sent by the state of Nagaland in that regard. Second is as regards the railways. The railways initially wanted to put the name as Molvom railway station. Now they want to, there is an apparent move that is being contended by the petitioner that there will be a change of the name to the other name, Mezefama railway station. That for that you have to file a reply. Two. The third issue is as regards the compensation, which the Deputy Commissioner has to take a call on that. Third. These are the three issues.
Yes, ma'am.
Nothing more.
Yes, ma'am.
But how do you take care of one thing? Although I'm not going to decide anything today. See your allotment order
My lord.
had certain terms and conditions.
Yes, my lord.
What was one of the clause number 1?
Which says the land is given to me and I will pay ₹1 to Mezifema, and the land will remain Mezifema's only in name, nominal.
So in the name it remains, so that is one of the terms of the year?
Yes, my lord.
Then how do you put it your name?
So from there, from 1940, Your Lordship, Molvom village came into existence.
Understood, but that is the term of your settlement.
Yes, no, it will remain Mezifema's in name. It means the ownership of the land, Your Lordship. I will pay Mezifema ₹1 annually, and the ownership of the land will remain Mezifema's only in name.
So you mean to say that the land would remain in the name of this particular village?
Yes, ma'am.
But then also that will the land will remain, but the name of the village will be different.
Yes, madam. Yes, madam.
Now, have your village been ever recognized by?
Yes, it is a recognized village.
How?
it
How
is-
do you know? Is it notified?
Yes, everything is there, Your Lordship.
Where is it notified?
It is in my, it is in my writ petition, Your Lordship.
I've read your petition. I couldn't find anywhere that it has been recognized.
Yes,
by-
yes, there's a list of recognized villages is there, Your Lordship.
Where is that? Show me.
And even in the, list of recognized villages, you know. Your Lordship can also see the report of the first general election, which is at page 139. Page 139. This is by the Chief Electoral Office, Nagaland, and then
Where?
Your Lordship will see at page 148. Page 148.
Yes.
And serial number 3, Ghaspani. Has Your Lordship got Ghaspani? Serial number 3. In the second line, on the Ghaspani, Volvom. Has Your Lordship got that?
But this is recognized in the year 1963.
Yes, my lord. Beginning from 1940, Your Lordship.
And this annexure at page 169.
Yes, my lord. List of recognized villages. Yes,
170 is the thing.
yes, my lord. At serial number 15. 168 is a type copy.
Anyways, chill. So today I pass an order as regards maintenance of law and order
My lord.
and remaining to be done by some other judge. Okay. The record reveals that by an order dated 21/8/2025, this court directed the Deputy Commissioner Sumikidema to file a report in respect to the law and order situation law and order situation in respect to the maintenance of law and order situation in the disputed a law and order situation amongst the villagers of Mezifema village and Molbom village.
My lord.
Pursuant thereto, an affidavit has been filed by the respondent number 4. Wherein at paragraph number 4, the details have been given as to what steps have been taken for improving the law and order situation in view of the disputes between the villagers of Molvom village and villages of Mezifama village. From a further perusal of paragraph number 4, it reveals that the law and order situation is under control. And no unwanted incident have been reported so far. It is, however, admitted that from the reports families from Molvom village residing in Mezifema town have been displaced, and students from Molvom village pursuing studies in Mezifema town have been affected. However, the list is awaited. Further to that, the district education officer had also instructed the school authorities to provide online teaching facilities to the affected students who are residing in Molvom village. It is further mentioned in the said affidavit, in the said paragraph, that though the law and order situation have improved, but still there is tension between the two villages. It has also been mentioned that the Mezifema Village Council, which is the respondent number 7, have expressed conditional cooperation, while the petitioners village council have raised grievances on the displacement and student safety. The challenges which the district administration face have also been mentioned in paragraph number 4 of the said affidavit. First, taking into account the reports so submitted by the respondent number 4, it is the opinion of this court that the state authorities, including the district administration, has to take effective steps so that the life, liberties, as well as the property of the citizens are protected, and the rule of law is sustained. It is upheld. Taking into account above, this court, therefore, is of the opinion that it would be in the interest of justice that the interim order which was passed on 24/7, 24/7/2025 be continued. And the state authorities, including and more particularly the Home Commissioner of the government of Nagaland, is directed to provide necessary resources so that the district administration is in a position to maintain the law and order situation. This court further would urge both the petitioner as well as the respondent number 7 village councils to maintain the law and orders, to maintain the law and order situation. So that the dispute between the two village councils can be resolved in an amicable manner. Next. It is further seen that the apparent dispute arose between the petitioner and the respondent number 7 village councils on account of for three reasons. First, on a purported move of the respondent authorities to change the name of the village from Molvom to Mezifema.
Yes, sir.
The second reason being that the railway station which is proposed to be set up,
Already set up, madam. Already set up.
which have been set up, and there is a purported move to change the name from Molvom railway station to Mezifema railway station. The third reason is on account of disputes arising as regards the entitlement of land compensation and apportionment thereof. Under such circumstances, taking into account that there is a procedure laid down by which the name of a village can be changed, and the last say being that of the Ministry of Home Affairs, Government of India, this court directs the respondent number 8 to bring on record their stand as to whether there is any proposal for change of the name of the village Molvom to the change of the name of the village Molvom. And any steps in that regard taken. In respect to the change of the name of the railway station from Molvom railway station, as alleged by the petitioner, to Mezifema railway station, the respondent number 9 and 10 are directed to bring on record their stand by filing the affidavit. Next. In respect to the question pertaining to entitlement and apportionment of the compensation, the respondent number 4 is directed to bring on record its stand as to any award has been passed in respect to the acquisition proceedings. And if so, and if any awards had been passed, then as to whether any compensation have been paid. The respondent number 4 shall also take note of, is also directed to, the respondent number 4, while filing the affidavit, shall also indicate as to whether the provisions of Section 30 of the Land Acquisition Act 1894 can be invoked for resolution of the dispute between the petitioner and the respondent number 7. First, list the matter again on when you are the person, Mr. Jamil. All of you have to file the affidavits.
Lordship, as per the last order, 3 weeks time was given.
No, no, I have to extend it now because I'm asking them to give some details.
Another 3 weeks time.
Okay. List this matter again on 26th of September, last date I put not, 25th of September 2025. The affidavits will be filed by 22nd of September. First,
Interim order will be extended, but
I have already stated the interim order is extended, isn't it? On top.
very much of
And further, I have made directions also.
Yes, my lord. Yes. Much like.
For hearing, item number 14.
Lordship,
Madam, what did you think?
Lords,
Yes.
Lordship, can you hear me? Lordship, at the outset, my lords, I would like to mention that there is some disagreement between me and the clients. So, my lords, I would like to seek discharge from your lordship.
Yes, madam, what do you
I
say?
was doing it pro bono and
I am, this is the first time I'm aware of this. Quite
No,
surprised.
it's okay.
But anyways,
It's okay.
we're appearing in person, so as our advocate has dismissed himself, we would like to carry on in person.
Yes, please, go ahead.
Yes. So, Your Honor,
Lord, can I leave, my lord? My lords, can I leave in that case?
Yes, sure.
My
I'll put
lords,
it.
there is one, please, my lords, please, my.
I'll put it. Yes, tell me.
Your Honor, on Friday you gave us advice, and you told us to hear your advice and to think about it and come back. So we've done that. The only thing that we're still confused about is that, Your Honor, me as a common person, if I forged signatures and tampered with court records, I'll be behind bars. So I'm confused. If I committed such crimes, would the court give the grace that is given to the accused advocate? I think not.
Madam, I'm telling you why. Whether the document is forged or not cannot be looked into in our proceedings under 226. The proceedings can be, you can very well, I can place it before, you can send it to and file a criminal proceedings. I can give you a liberty to do it, proceedings under criminal, where there can be a forensic examination, because you require a forensic examination in respect to this. If you want to do it, there's no problem. You want to go ahead, you can go ahead. But the fact remains that you are just, I said to you, because of the fact that you will be, what you means in respect to the present matter, if you want only to insist upon that lawyer concern, very well, you can go ahead. But at the end of the day, from the report which is being given, I'll open it.
Yes.
If in the report, if it is given that it cannot be done by the registry, the direction which has been given, the problem which will happen is that the only remedy you have is to go before the criminal court, file an FIR against that lady. And then this will again start a new course of action,
Mhm.
for which it will be sent for the purpose of as to whether the signatures are true or not. This will have to be done. But if the report says that yes, the report it is a conclusive proof that there has been a forgery, then obviously this court can initiate proceedings under 340 and direct the way how it is done is that I'll direct the register to file a criminal complaint against that advocate. But you have to take that risk.
Your Honor, she has admitted on her affidavit and in open court multiple times that she did in fact tamper with the Vakalatnama with whitening fluid. The Vakalatnama that was already 3 months within the registry's possession. She has admitted
No, she,
on oath in open court multiple times to 2 different judges. So what else is left if she's admitted it? And all the court has to do is check the Vakalatnama, which is there in the registry, and it will see the whitening. It will see the forged advocate signature from Delhi, which the Delhi advocate has stated multiple times that let this court pass any order requesting her to put her affidavit, she will put it and she will swear on oath that that is not her signature. I also have the emails,
no,
Your
the
Honor.
question is, as regards the Vakalatnama, what is the issue involved?
Pardon?
What is the issue involved as regards the Vakalatnama?
She tampered with the
Now,
Vakalatnama.
the question is, did both of you issue a Vakalatnama in her favor or not?
Sorry.
Did both of you
Mhm.
issue a Vakalatnama in her favor or not?
We signed the Vakalatnama.
In her favor or not?
I am not sure what you mean in her favor, but she was our advocate. We
So
signed the
did you
Vakalatnama.
appoint her as your?
Yes, she signed it with her juniors.
Both of you, did you sign that Vakalatnama or not?
At the time, I wasn't a petitioner. My husband signed it. He was
You
petitioner number 1
signed
at the
the
time.
Vakalatnama,
Yes, I do sign.
thereby appointing her as the lawyer?
Yes.
What is the forgery done?
She cut her name and she forged again another lawyer who is from Delhi. And that lawyer is telling us that if the court passes an order, I will file an affidavit saying that it is not my signature. And we saw her that Vakalatnama to her said, this is not my signature. She told us.
Who is going to say?
Mukta, the one who is in Delhi, Advocate Mukta.
Mm.
Where is he? Has he filed an affidavit before this
Her
court?
name is written there in the Vakalatnama.
Where is the Vakalatnama? Let us see the Vakalatnama.
Your Honor, the original Vakalatnama will be with you in book 1.
Huh?
Your Honor, in IA 65, Annexa D. That is a photograph which was taken in the registry of the front and the back of the original Vakalatnama. But I think the original is there in book 1.
Where is the affidavit? Vakalatnama? In IA 65.
Annexa D, Your Honor. Page 35.
Page?
Page 35.
Okay.
It's very clear to see, even in the black and white photograph. In the original, that which is in the court's possession, is more clear to see the whitening fluid. And she has admitted in her affidavit, Your Honor, she's admitted it
Who is Mudga?
is a Delhi advocate under the same organization that they were all under the same human rights law network.
Ah.
She was in the Delhi office and Ms. Koza was in the Kohima office.
So who signed this?
Which part of this, Your Honor?
This wakalatnama is signed by whom? I see the original wakalatnama here. I have it.
The signature says Mugda.
Who has signed this wakalatnama?
If you go to the next page,
You
can
have
see-
signed it, the next page? You have signed it.
I have signed, yes, Your Honor. Yes.
Okay. This is the wakalatnama signed by you. Are you sure?
Yes, Ajaveni. Here.
Oh, yes, Your Honor, I decided.
Okay. You signed it.
Yes,
Now, why did you sign this wakalatnama?
because she told us that she's going to represent for us.
Yes,
She would represent for us, she told us. And I said, okay, then go ahead.
So she will represent you.
Yes.
Yes.
I'll go
Okay.
with this.
So you mean to say you signed this wakalatnama without her putting her sign?
No, Your Honor, she signed in the taxi with us. She was with us when she signed it. She signed right here.
Where?
She came to our home in Mitsipima town
Uh,
to get our signature on the Vakalatnama.
Understood. Here
And she signed?
you put the names.
No, she signed here
Yes.
and my husband signed.
Understood. No, madam, I fail to understand. You
Yes.
see, kindly read it. Know all men by these presents. The above name do hereby nominate, constitute, appoint Srimati, so and so Mudga. Okay. But where is her sign in the Wakalatnama? You see, you in this column, you only put their names. You don't sign
Okay.
here. The signing takes place here for the advocate. Accepted. Where is her signature here? Where it is required?
Right, well, she took the Vakalatnama from us, so
So
obviously
where is
she'll be the one
forgery-
filing and
where is
signing
the
filing.
forgery committed by her
She admitted in her affidavit, Your Honor,
regarding?
that she removed her name and her junior's name from the Vakalatnama and added
You
Mugda's
see,
name.
you have appointed. But
Yes.
where is her accent?
If she did not sign it before filing, then that's her issue and the issue of the filing office,
No.
because signature should be present,
No,
right?
No, madam.
That's not our responsibility,
No,
because we're not the ones
it's your
filing.
fault. I'm telling you why. A person you are issuing a power of attorney. This is
Yes.
Wakalatnama is a power of attorney.
Yes,
When you issue a power of attorney to somebody,
right,
the power of attorney has to be accepted in your presence.
right.
Where is her acceptance?
And
in
how
this-
did the filing office and the registry accept a Vakalatnama that didn't have a signature from the advocate? And how did she come into this courtroom and represented us? How did the court accept the Vakalatnama then?
Because her
If
signature
the
is
court
not here.
claims that a Vakalatnama must have the signature before the filing, then
Lordship, sorry for interruption, but this IA has already been disposed of. The IA
no,
has
that's
already
not,
been disposed
it's not completed
So they
and it's not.
raised,
to do with
not
it.
for the advocate to make
Yes,
assist
you are for the
this court.
state.
to assist the court, Your Lordship. This IA is disposed on 17/7/25. They can only make an allegation only in the presence of the concerned advocate, not in her absence.
Well, she didn't come, that's not our fault, is it? And this has already been heard by two benches in court 1 and in court 2 by two different judges. The hearing went on. She has spent 2 hours defending her side. We've spent 15 minutes defending our side. All the evidence was looked, and the court came to the conclusion that yes, an inquiry should take place. Wait, yes, this is not one. And she has claimed in her affidavit and in open court that the registry allowed her to do all these things.
Huh?
That is her allegation, which is very serious allegation against the court. So we ask that you uphold the dignity of the court and please open the inquiry from the registry, Your Honor. That one. Page 20, no, page 20.
So your allegation is only in respect to that force FIR, no? Wakalatnama against her?
No, the
What is that?
forgery on IA, on multiple IAs, the forged signature. Your Honor, if you go to IA 65, annex, starting from page 37,
IA 65 was filed by?
by us, Your Honor, the petitioners. Page 37 to 41. You can see that all the signatures are different handwritings, even different spelling, even different name.
Page?
Page 37, starting at page 37, Your Honor. Annexa E.
So you mean to say that these signatures are not of that person?
Yes, it's not mine.
Yes.
37, 38.
Yes, in IA 15, 16, 18, and 20. 17 is my husband's signature, Your Honor.
And at page 42?
Page 42, it's his passport from 2015. You can see the signature is the same as the IA 17, which he did sign. The other signatures, the handwriting is completely different. Even the name is different on some of them, Your Honor. Like, for example, in page 39, which is in IA 18, it's Aja Von Lee instead of their new. Like, who will forget how to spell their last name? And even in IA 20, page 40, you can see the handwriting is completely different. And again, in the IA 15, again, the handwriting is different.
Okay, madam, the signature which appears at page number 22 of the
Yes.
passport
Yes, Your Honor.
is not the signature which is there in the writ petition.
Your Honor, of course, everybody's signature is slightly different.
No, if then we should
But-
dismiss the writ petition as not being filed by him.
Then if the court wants to verify to be very sure, then the court can order for
It
forensics.
is on affidavit filed by somebody that this is the signature which you are relying upon for the purpose of verification. That
And
is
IA
page-
17, Your
that is
Honor.
That page 42 of IA number 65.
Yes, and page 41 as well, Your Honor.
42. Now, this 42 is not the signature which appears out here in this particular page.
You mean in the Vakalatnama, Your Honor?
In the affidavit or even in the Wakalatnama. So
In
the
the-
filing of the writ petition is by somebody who is an imposter. So therefore, as you don't insist, you say that this is not the signature of the person concerned, we dismiss the petition on that ground. Go.
Sorry, Your Honor, you mean the writ petition?
I'll dismiss the petition on that ground.
Can you clarify, do you mean the writ petition?
Yes, the writ petition, the signature of the writ petition
So-
person is not the same
Okay.
signature which appears out here in the passport.
So Your Honor will dismiss the writ
Writ
petition, which includes the protective
Because
order for the
signature
baby's
is
life.
different.
Right, so what Your Honor is saying is that
I
the
dismiss
court will
petition.
dismiss the writ petition, which includes the protective order on the baby's life, in order to protect a
Giving you the
criminal.
liberty to file a fresh one if you desire so. Because you yourself say that this signature and that signature have to be compared. the signature which is appearing in the writ petition in the affidavit filed by so-and-so on Mr. Henjanguli,
Yes.
is different from the signature which
Your
is
Honor.
appearing here.
Your Honor, if you mean the last page of the writ petition, as you can see from our IA 65 and our rejoinder, that was one of our complaints as well, that she never gave us the final writ petition before filing. She went and filed it.
So
It's there in the emails as well.
That means this is being identified by one Kukun, by some advocate. Fuka.
We were not given anything before filing. She changed the petition.
So
The emails
therefore-
are there as well
So therefore
from the
you
Delhi
don't
office
know-
confirming that.
Here you have given a name of somebody, somebody's Aadhaar card has been given. All these things have been given. So therefore, the question is, the filing of the instant writ petition has been by somebody else. So therefore, we cannot go ahead with this petition also.
Then if the court is going to lift the protection order on my baby's life, the hospital will go ahead and try to take her off the ventilator.
So that is why I told you to be more careful when you are making that, insisting on some things which has nothing to do.
I think that's extremely unreasonable, Your Honor. A baby's life is at stake. This is not between us and the advocate or us and the court or hospital. This is a baby's life that's at stake. She is on ventilator.
Madam, everything is understood. You cannot on one hand be unreasonable enough.
I don't think
I told you very carefully or clearly on the last occasion. You want the question as regards the baby's life, we are going to do the needful for that so that the baby is protected and being taken care of. Don't worry with that. I said that as regards the reliefs which you are seeking out here, certain reliefs you could not have brought within the ambit of the writ petition. These reliefs have been taken away at the first instance when Ms. D. Ghosh had appeared. On that very date, she said that these reliefs can be taken out. That she would not be insisting. This is the first order.
Right. And why didn't
on
they?
that basis, on that order, first order itself, the baby has been protected.
Yes.
And I was the person who had passed that order, the first order.
Yes, Your Honor.
And it has been protected. The baby has been protected because of the first order. And then in that order only it has been mentioned by Ms. D. Ghosh, who was appearing on behalf of the petitioner, that look here, I would not insist on this other reliefs. The reason why it is so, because all other reliefs which you are asking for cannot be adjudicated in a writ petition. Secondly, as I said on the last occasion, all these reliefs you can very well challenge out there or go before the consumer forum to get it done if you want. But this court is not going to entertain, because here we are only concerned with the baby. And if you remain like this, I can't help it. Nobody can help it. No judge would be passing an order in your favor. I'm making it very clear. Don't take the advantage of that this court, because of the baby, you are trying to blackmail this court. Don't do that.
I disagree, Your Honor, completely. If the court turns a blind eye to forgery and tampering of court records, then how can we, the common people, have belief on the justice system, have trust onto the court that it will uphold the law, it will uphold justice? Where is the justice, Your Honor? How can I stand before this court and believe that the court will be fair? The court will listen to the hospital side, will listen to our side, and come to a fair conclusion. How can that be? How can we have that belief in the justice system if the justice system is saying that you as a common person, if you commit this type of crime, you will be locked up? But if our own staff does it, then it's fine. We will cover it, no problem.
The common law says out here that the law says that if there is a manipulation in the court's records, the court can very well direct that for making an investigation. And
Yes.
after the investigation, any report is given, holding that the report is conclusive, then a proceedings under 340 can be initiated before the criminal courts.
And that's all we've asked for, Your Honor. We've only asked for.
But
the
if the
court to
report,
investigate.
madam, I'm saying if the report is inconclusive,
Yes.
then I cannot direct. And if that be so, then you have no other option left. You want to see, I have not opened the report. You want to see the report?
Yes, Your Honor.
Have a look at the report. What is it? Then you will understand. The moment you open this report, it goes away from my hand and I have to close your petition. And then I cannot do anything. See this. I put it at the ball in your court. Open it. I have not opened it. Open it and find out whether it is conclusive or inconclusive. The moment it is inconclusive, my hands are tied.
Then I will take the certified true copies to a forensics lab to get it tested.
You can very well
If
take
the
it.
court is unwilling to do it,
No,
I will have no choice but to do it by myself.
Madam, I cannot do that. But that is one aspect of the matter. Now let us take up the question as regards whether the further interim orders can be continued or not. We'll look into that. Now let
Your
us
Honor,
take up the matter on merits.
Your Honor, she has even on her affidavit in of the court,
Madam,
she has defamed the registry,
Madam, I will
saying that
pass
the registry was
Madam, I will
complicit
pass
with her
an order.
crimes.
No.
She has defamed the registry
Madam,
even
when you are
outside.
appearing before this court, you have to maintain some decorum. I'll pass
Yes,
an
Your Honor.
order in that. Now let us hear on merits of the writ petition. Because the matter has been pending for the last 3 years.
Yes, Your
Let
Honor.
us hear as to whether you are entitled to the reliefs. Argue this.
Your Honor, all the prayers were removed, so the only reliefs that are left in this case.
I will allow all the reliefs. I will allow for you to argue on all the reliefs. Argue.
Well, the reliefs are no longer there, and IA
All
58 is
those
still removed.
reliefs which are no longer there also, I
Yes.
recall that order and allow you to argue. Argue now.
As far as IA 58, which is to put the prayers back.
Forget about 58 or 68. I'm concerned with the writ petition.
May I please submit certain things, my lord?
No, Mr. Counsel, I'll hear you after some time. Let us hear the petitioner first.
Okay.
Argue on all the reliefs.
Your Honor, the case was filed in 2022.
Issue a direction to the respondent number 1 and 2 to provide the complete set of medical records associated with the treatment of the petitioner's daughter ever since her birth.
Which they never complied
Okay.
with.
We will allow that. Now, issue number 2, issue a direction to conduct an independent inquiry into the negligence committed by the respondent numbers at various occasions through the 3 admissions that the petitioner's daughters have been through ever since her birth, and due to which she is looking at a life of complete disablement, and thereafter prepare a detailed report and place it before this court for further action. Okay, we allow this relief. Number 3, issue.
Your Honor, if I may, please.
Yes.
Your Honor, on the Friday's hearing, you advise us 2 things to take into consideration, which is the IA 58 and the IA 65. So IA 58, if the court doesn't want to allow the price to be put back, that's fine. We will approach the consumer forum. We have no issue with that. Now, IA 65 has concluded.
You can even approach the consumer forum against the lawyers. There's no quarrel with that.
I don't want compensation. I don't want anything from the lawyer. I just want to have belief and trust in the court system.
We'll
That's
take
all.
care
And
of
since
that.
the crime was committed in this court,
Madam,
then
we
let
will-
this court take action.
I tell you, we'll take care of that.
No matter whether it's a small fine, whatever it is, that's up to the court. We don't care about that. We just want to, again, have trust and belief on the court system, on justice. Because how is it that the court can treat one person? There's no class system in the law. There is no class like one profession.
No, madam, wait. You are only concerned with prayer number D, E, and F being withdrawn. As regards ABC, this court is willing to pass an order or is inclined to pass an order to that effect. D, E, and F issue direction to the respondent number 7A to take appropriate legal action against for gross negligence. This gross negligence aspect can be only looked into by way of evidence. That is one. Or if I pass an order in terms with C, an interim order, by which there is a direction for making an independent inquiry,
Yes.
then on the basis if it is so-and-so. But the fact that here that independent inquiry would be ex parte you cannot participate that. And if it goes against you here, you have a problem as regards the relief at D. As you are petitioners in persons, therefore I'm explaining to you.
Yes, Your Honor. Thank you, Your Honor.
Issue direction upon the respondent number 1 to reimburse the medical expenses paid by the petitioner to the hospital for payment for treatment and waive the pending bills. Now, as regards the waiving as well as directing all these things as to whether you are would be liable to pay or not, this court have by way of the interim orders have allowed your baby to be under the treatment of the Christian Medical College.
Yes.
So it has been going on for the last 3 years from this court. So this you are already getting that benefit of F. As to
Yes,
whether
sir.
you have to pay or not, that this court will duly take care of it. Don't worry with that F. But the fact why I asked at that point of time to the lawyer is, when you are asking the question of a liberty of the rights of a life, right of life of the baby, you should not ask these, because this was a matter being moved by a council in respect to a consideration as regards a baby's life. So if you have anything which has a pecuniary interest, then obviously it would affect your right. Now here, just for example, the state of Nagaland was not made a party. When you filed the writ petition had a lot of lapses. The state of Nagaland was not made a party. I passed an order out there on the first day to make the state of Nagaland a party, so that the land which had been given to Christian Medical College was a land which was allotted by the state.
Yes.
And therefore the state can very well tomorrow direct them to make the payment or give some benefit in terms with the judgment in Mulchand. Your lawyer, if you see out there, nobody argued all these things.
Yes.
This is not required for that. But for that, these courts have passed these orders. Now, as regards D is there. D is, if I pass an order of C in your favor, an inquiry is being done as regards negligence, if I pass an order, D is consequential.
Yes, Your Honor.
If there is a negligence found in the report, it is consequential. What action can be taken? The problem is like this. If this court is to pass an order, this court will pass an order in terms of a constitutional tort, where the limit will be less.
Yes, Your Honor.
Where it is a case of not a constitutional tort, but it is a case of compensation. As I said on that day to Mr. Jain also and to also,
Yes,
you have a look at the judgment in Master Ayush, where a child had developed a particular disease on account of failure on the part of the hospital authorities. And the court directed them to a payment of around 1.27 crores. This was the amount which was given by the Supreme Court. So therefore, if C is given, the consequential is D. But if you have D out here, the problem arises when you file an appeal against these type of orders, that this person concerns were actually behind the money. And now they are trying to blame. What is the case which have been projected by Christian Medical College? They say, that look here, we gave them all the help. We have given all the help we have. Now we are not in a position to provide help, and we don't have also the resources to treat the child. That was the situation which was when the matter came up before this court. And now what is being said out there by the Christian Medical College on that day or the next day is that, look here, now in order to waive off their bills, they have come with this. Now, if
Yes, and they have provided zero evidence of that. It's all baseless allegations.
these are
The facts
madam,
are there in
these
the
are,
medical records.
madam, these are questions of facts.
Hmm.
You see, this court have limitations.
Yes, Your Honor.
I cannot go into certain questions of facts. These facts can be only proved by evidence,
Yes,
which
Your
a
Honor.
consumer forum court can do it, as I said so.
Yes.
A civil court can do it, where evidence can be laid. What you are saying before me can be said by way of affidavit evidence out there on all these things. But these things, they were giving this flavor. So these three, if this D, E, and F is waive the pending bills. Pending bills which are there now, we have by way of interim orders, we have getting it.
Yes, Your Honor.
The baby is still under the care of this year.
Well, that impending order, the hospital, despite that order and despite the judge directly telling them that they should not file in another forum, they have filed in the district court for the bill, despite this impending order.
Okay.
And the district court said that they will not go forward. It's paused until the
The
High Court passes an
the
order.
district court has not gone ahead because the matter is being pending.
Exactly.
And
They were
they-
forum shopping, Your
And
Honor.
more particularly, when in the first interim order, I categorically mentioned that any amount to be paid shall be decided by this court at a later stage. If you
But they
see
still went to
first
the lower
order-
court for a different decision. They were forum shopping, Your Honor.
Huh?
They were forum shopping. They disregard the order of the High Court and went to a lower court, trying to get a better outcome.
You see this order.
Your Honor, every order that,
Entitlement of the respondent number 1 to the amount as claimed in the legal notice as well as the treatment net area shall be considered on the returnable date. And thereafter it has been extended. Yeah, so and so is directed respond to continue to provide the present in the method area. The said result shall continue to do taking into consideration the best interest of the child.
yes,
These are orders which I had passed at that point
Yes,
of
Your
time on 18-2. Now, therefore, the question is, if you insist on those, you want to prove medical negligence later on. This court can very well pass an order for making an inquiry, but then inquiry will be very limited.
yes, Your Honor.
But I can hold the medical board. You see a judgment of mine in the case of it is reported. I'll give it to you. Have a look at that judgment. I constituted a medical board to look into what is the condition of the baby and how this can be improved. An inquiry which took around 4 months to give a report before the court.
Yes.
And thereupon their report was submitted that there was no negligence on the part of the But there you have no say.
Mhm.
Whereas in a medical negligence matter, which you can go ahead in the other matter in before the consumer forum, you will have a say. You can give doctors evidence out there.
Yes, Your Honor.
So therefore, it would be in the interests of the child that you take care of the matter, what you want, ABC. Once ABC you are getting, then DEF is consequential. F is already taken care of. E is already there. It is only the case of D. D cannot happen without A, B. Once B happens, then you have D. So DEF being removed also does not affect you. And if B is decided in your favor, if I direct this in your favor, then D is consequential, as I said.
Your Honor, as the court has stated that it's only interested in the fundamental rights of the baby.
Madam, you understand. The question is, you don't need to antagonize those other people. I understand the status of you as regards being the mother of the child. You are at that, but we try to help you out. I'm trying to help you out. But if you are trying to antagonize all lawyers out here, they would not also help you. If you understand me. So, you see, I am today sitting out here. I'm not going to be here for the next week onwards, and
Yes,
I'm
Your
going to
Honor.
come in the month of October, December or January or February. I'm not going to come before that. But this explanation nobody else will do, even to you. Passing a direction against that lawyer would not have any problem for me for passing an order and looking into this. But the moment I open this, the problem which is happening is I have to pass a direction.
Yes.
And if it is inconclusive, the report, then I have a problem later on that I have to drop that proceeding, everything finishes. Once that is dropped, the Bar Council complaint also gets dropped.
Well,
You
I
understand?
will appeal, Your Honor.
Huh?
I will appeal, Your Honor.
Where?
In the National Bar Council. And also, I will
Madam,
take the certified true copies to get
nobody will
forensic
do anything
examination.
if I drop it. If you say to me that instead of going ahead with all these things,
Yes, yeah.
you go ahead with the Bar Council complaint.
The Bar Council,
You have filed a Bar Council complaint, go ahead with that against the lawyer. If you go ahead with against the lawyer in that Bar Council complaint, then there's no problem. But if I drop their proceedings, 65 or whatever may be that proceedings, saying that this is inconclusive, the Bar Council will be bound to drop it. And thereby, the effect is the next proceedings. In appeal also, nothing will happen because there is a judicial order. So you go ahead with your Bar Council. Because the Bar Council can hold an inquiry, can send it. And if it is found that there is a defect or they have committed some forgery, her license would be cancelled. It's not a matter of joke, her license will be cancelled. Again, you see, this court, in view of a Supreme Court judgment, cannot also cancel a license. I cannot cancel a license.
well,
Also.
I've not asked for
No, I'm saying
for any type of punishment. Just
no, this is you see, once it is shown before this court, yes, there is a forgery committed, then this court will be bound. You see, that is why I have not opened. From day before, 3 days back, this is lying out here. I have not opened because of the fact the moment I open it, the problem arises. So instead of that, let us take up the matter out there. I'll explain it in my order. The DEF is consequential as regards A, B, and C. And as such, in spite of D, E, and F, these are consequential, which will have an impact on A, B, and C. And this court having already passed an order for the child being protected or given the treatment. So F has also become inconsequential, and they will continue to do so till the next hearing. I think this would be better instead of taking the child and giving you the liberty. And if you want to, I can pass an order as regards B. Holding an inquiry of the medical board, directing the medical board, the officers out here, to conduct an inquiry as to whether there is a negligence. Madam, what do you say? Let them look into it.
Yeah. Since they want to prove the medical hospital as medical
No, madam, if you
negligence,
see the
it is
judgment,
for them to approach the
madam, if you
right
see the judgment in the case of Jacob Matthews, if a person has to go before a consumer forum also against a particular person, then there is a report, a medical report required. Now, the medical report which will be there, because in another case, I've said as to whether there was any negligence. These can be seen from all these documents which they will produce. And I give them the power to look into those documents and submit a report within 4 months.
Exactly.
And then the consequences will follow. If they say, yes, there was negligence, then D automatically comes in. You don't need D for that. This court can very well pass an order for D.
Yes, Your Honor. Your Honor.
My lord, I may please hear. I may please.
E and F also comes in. Yes, what do you have to say?
My lord, generally, court and public forgotten the problem faced by the respondent one. It is a premature baby, 30 weeks instead of 40 weeks. And delivering a premature baby in an hospital is not the mistake of an hospital, my lord. She delivered the baby.
Mr. Abraham, let me
Hold me,
tell
hold
you.
me.
No,
My
Mr.
lord,
Abraham, can you, if you hear me, let me tell you. you may have some expertise on this aspect, but me as a judge, I don't have an expertise as regards whether there has been a deficiency or not. So you can very well justify your actions.
Word, my
I
lord,
cannot
one word.
justify.
One word.
I cannot say, I cannot look into it unless I get a medical opinion as to whether there was any negligence or not.
One submission, my lord, one submission.
Yes.
For the last 4.5 years, our doctors have been looking the baby, and other babies were neglected because we are looking into that. So there are so many allegations, and against the doctor who saved the baby for 4.5 years, this complaint, these state petitioners have filed a complaint under culpable homicide against the doctor himself. My lord, I never heard in my service a complainant, a patient is making a complaint under culpable homicide against a doctor in the police station. The doctor being the treating doctor for the last 4.5 years for the same baby who was born with so many problems with the organs. The organs were not grown because normally the gestation period is 38 weeks to 40 weeks. The baby was delivered at 30 weeks with the weight of 1,100 grams instead of 2,500 grams. Now you can imagine, my lord, it is natural, it is science that those babies delivered prematurely will have infection, etc., etc. But the common sense is the hospital which saved the baby for 4.5 years, and it is now the baby is more than 102 centimeters length. She has grown. She is not a baby now, she is a girl. And the weight is 15 kilograms. And the last 4.5 years, my lord, please, these two writ petitioners are going, visiting, unnecessarily shouting, taking photographs, videograph. Every complaints have been done. And all our employees, my lord, they have been doing the duty as per your direction. We have never demanded the money. And the bill is more than 1.5 crores now. But we never demanded. We are giving the same treatment. And my lord, the other side is, perhaps it is a misplaced sympathy. All other babies which requires very, very, very important treatment have been neglected because of this baby. Now, the writ petitioner number 2, she belongs to Portuguese country. She is comparing the treatment given in India and Portuguese. Now she every untimed time she gate crashes the hospital and shouting against the treating doctor. My lord, it's an empathy. We should place ourselves as a doctor. For the 4.5 years, the man has been struggling to save the baby. Now, he has written so many letters to the management. Please leave me. If something happens to the baby, they will arrest me. They will put me in jail. All sort of anxiety has been expressed by the doctor, my lord. Where we have to go? It's actually, slightly speaking, it is misplaced sympathy. We have every right. And I want to clear another doubt also, my lord.
Mr. Abraham, what is the present status of the baby?
It's going on well maintained. We are giving the same treatment and the baby is all
Your Honor, I
right.
object to that. That's not true.
It is at the base. I am representing the hospital. So as per the advice from the hospital, I'm telling you.
No, Mr. Abraham, what is the present status of the baby? Means is the baby in the vegetative state or what?
My lord, we have expressed that our inability also. We requested the writ petitioner asked them to take the baby to a somewhat specialized hospital than this one. As per Paramananda Kattara case, we stabilized, we maintained, and we kept the baby till these 4.5 years. Now the time we are begging that the baby can be shifted to All India Institute of Medical Science in Gauhati, at least, so that very easy to transportation. It's a medical college. My lord, I want to make it clear, we are not medical college. We are a 200-bed hospital only. We have been founded by 3 people. One, state of Nagaland, by giving land by lease only. We are paying lease. Other than the land for lease, the state of Nagaland has no connection. We are completely private. And the doctors from CMC Vellore and Emmanuel Health Association, the 3, state of Nagaland, Human Health Association, CMC Vellore joined together, and after seeing the health condition of Nagaland people, they started this hospital. It is a mission hospital where service to the people is main objective. Attendant factor is income. We are not running for income. While so, for the last 30 years, nobody refused to pay the bill. This is the first time 1.5 crores is pending, and we respect the order of the High Court, and we never pressed them. They asked medical bill, they asked medical records, everything were given after getting acknowledgement. We have also submitted the bill, and we hear that the writ petition number 2 is a wealthy lady having enough resources, but she is misusing the procedures in Indian judiciary. To my experience, I'm telling, this is actually misplaced sympathy. Sure, there is a Supreme Court judgment.
What is your source of income, both of you?
I'm a housewife, Your Honor. And my husband,
Huh?
he's a daily wage worker, Your Honor.
Daily wage.
Yes.
I was used to be a pastor
In Assam,
in Assam, the border of Nagaland, Karbi.
but due to the condition of the baby, we cannot continue because pastors will have a tenure of 3 years and then they will be shifted to another place, could be further away, another state, so forth, as missionaries. But our baby is there, so we cannot leave her side, no? So for that reason, we've been struggling a lot. Your Honor, if I may, just very quickly, reply to two
One more
things that
supposition. My
the
lord,
husband
there's a
has
lack
said.
of confidence, lack of trust. And these writ petitioners are making complaints against many people, not only we, hospitals, doctors, lawyers, and wherever they go. Even they hired a lawyer in Delhi. That man is also not able to continue. Now, if my lord and the court can understand how they are behaving with Indian institutions and Indian professionals. We are very humble, we are simple, we are always for mission. But one last submission is, we asked them, we gave a form to take the baby to some.
Who is your local council, yeah?
Pardon, sir? Pardon?
The local council?
Yeah. Yes, yeah. He is with me. He is my junior.
Sir Fazakois.
Huh?
Sir Fazakois, he's the local council lordship. I am his junior.
Okay.
Your Honor, if I please may.
Take submission. One submission, my lord. One submission.
We'll have the matter on Wednesday. Give us a status of the baby. What is the baby's status? Medical, just medical status, whatever may be. Not so in medical terms for me to understand.
Lordship.
Okay.
Lordship.
We'll have it on Wednesday.
Lordship.
After 2.
Lordship.
Huh? Just give us a medical status of the baby and where that baby can be treated elsewhere.
Lordship.
Can it be treated in government hospitals or can it be treated in Assam in government hospital? Because at the time when the matter was taken up by me in 2022, that disease which the baby was inflicted with could not be treated in the northeastern region.
Lordship.
But is it now available in any other places? Then we can very well, because one has also to look into the state, because they are saying you cannot keep on insisting upon them for the last 4.5 years, they have already kept it. So we'll consider that.
Last submission, my lord. Last submission. One word. Only one sentence. My lord, thank you, my lord. The baby can be visited and examined by a medical expert other than the Christian Institute of Health Sciences and Research, other persons, maybe Nagaland Medical Council, etc. Let them have a review. After that, it is all, you see, all the judicial pronouncements were there. Best interest of the child. Leave alone the hospital or the petitioners.
Mr. Ibrahim, all things are said is okay. But at the end of the day, this court cannot also put this hand out of it and say that the moment the treatment of the baby is taken out, she would not survive. That this court would not do. Now, therefore, some solution can be reached. Give us a solution. You are a senior counsel. Give us a solution. How can this court?
Let us get an independent review by an expert, Nagaland Medical Council, etc. After receipt of that report, and the recommendation. My personal submission is
Madam Supra, you are the additional advocate general. Give the names of two medical examiners. First, we need
pediatricians.
one for baby. What do they say?
Pediatrics.
Pediatricians.
A pediatrician, and what is the ailment of the baby? Anything with the neuro?
Your Honor, she would need a pediatric pulmonologist and pediatric neurologist, which none are available in the state of Nagaland.
No, we'll get it. Don't worry. A neurologist is neurology.
Your Honor, I have no objection to their request to have a independent expert.
Because this will take care of your prayer B.
Your Honor, as long as we can we will request
No,
that
madam, what is your
we also submit our questionnaire to that expert.
understood? What is prayer B? Your prayer B is that you need an independent inquiry being done by somebody as to whether there is a negligence or not.
The hospital is not asking for that. They're asking for the condition of the baby or whether she can be shifted.
No, the condition of the baby will take care of it. That will be also given. But there will be also an order as to whether there was an apparent negligence on the basis of the materials which they will produce. I don't think Mr. Abraham will have an objection. That is, you just find out these two persons, one a neurologist.
If it's a neurologist concerning with children, baby, I don't think we have.
There isn't in the Northeast.
Neurologists are lot of neurologists.
Those are adults, Your Honor. It's
In
quite different.
Gauhati, we have a lot of neurologists. In fact, I tell you this matter, I read it. What was the name? Binoy Kumar Deka. You see that judgment, it is reported judgment. So there, this particular person looked into this aspect. And we had an inquiry as to whether there was any negligence on the part. After that, it was said that there was no negligence. And the second question is how steps can be taken for the purpose for the baby to survive. This is a very important thing. Now, in that case, the baby was in 2014. I got the matter in 2021-22. Then I passed this order. Then after this passing this order, then ER is being given. Now they say that there will be a requirement of certain. So we involve the social welfare department for giving the chairs and all. We involve the state, the director, the pediatrics department who looks into all these things and gives. And every 6 months I get a report. So the matter is continuing everything, and I get a report every 6 months from that court. But the only thing which I require now, if you can just give me 2 names of a pediatrician, Mr. Ibrahim, would only a pediatrician be enough?
Oh, yes, my lord, is enough. At least as a lay person, we can understand the condition of the baby.
Understanding the condition of the baby is okay. But as to whether there has been, what is the problem with the baby? Has anything to do with
Your Honor, if I may, just one
My
thing.
lord, the gestation period is 30 weeks. So generally,
Your Honor, AIMS has filed via the union.
all the vital organs will not be grown. Breathing,
Via the Union
all
of
the vital
India,
organs will not be grown.
AIMS has filed this letter and they have categorically said that the baby does not have a rare disease, which the hospital has been claiming all this time, saying that the reason for the baby's conditions is because of this rare disease. AIMS, 4 expert doctors from AIMS.
Premature baby, 30 weeks with a
And connecting.
Yeah, he was sequel of prematurity and adverse prenatal conditions in the form of money. So bilateral profound hearing loss, bilateral malforming. Parents are being counseled by the treating team about the prognosis and also all favorable and favorably based on the basis of demand and being offered seems appropriate and transferring the baby out to AIMS will not change whether as he is primarily needs supporting care, shifting may not be a sustainable the financially also it may not be challenging but we have to shift to the then they agreed that shifting the baby to AIMS then they shall not offer any additional And we also noted the application for amendment was submitted to the rare disease committee, but the case does not fall into the rare disease. So it is not a rare disease aspect.
No, Your Honor, but they're still trying to claim that even with the four expert doctors from AIMS, including Professor of Urology.
So
And yet they're still
it
here
is a
trying to
question
claim
of
that.
treatment being given.
Your Honor, she has brain damage because of a lack of oxygen, because of the multiple hospital-acquired infections that she has received at a young age in the ICU, including intracranial infections. That means the infection went from the lungs to the bloodstream to the brain and completely damaged.
From this letter, it seems that you were counseled.
No, we wasn't.
It's written out here, na? Parents have been counseled by the treating team, by the AIMS.
No. Treating team, local
No, I'm
hospital.
asking you whether the people out there in AIMS have counseled.
No,
them.
we had no, only the hospital had a meeting with them. We didn't get the opportunity to have any type of meeting, or it was not a fair meeting actually. But
Then are you saying that the first line in paragraph number 2 is wrong?
no, they're talking about the hospital.
No,
My submission.
I'm not saying that.
My submission.
Have been counseled by the treating team.
Yeah, the treating
About the
team of the baby.
prognosis and overall unfavorable outcomes.
Yes.
Who has counseled you?
That's the treating team, as in her doctors here in Nagaland.
They have.
They told us about the brain damage.
Based on the details provided regarding the present clinical status, the treatment being offered seems appropriate and transferring the baby to AIMS is not required. The rare disease is committed, but the said case does not fall here. Okay.
She doesn't need specialists because there's no cure. She doesn't need these specialists because there's no cure. She just needs to be on a ventilator, have nurses taking care of her, right? Somebody taking care of her because she cannot move. She cannot go to the toilet by herself. She needs to be changed. She needs to be fed via a tube. She has a tube in her throat, which is connected to a ventilator and oxygen. She just needs that care, which, like Aim said, that care is already being provided in this hospital. There's no reason to shift. It's just going to put a huge burden on us, the parents.
My lord,
Your Honor.
If that be so, why the state cannot provide that thing?
Lordship, we have to look into the laws because we have to see the resources of the state. No resources is limited, unlimited, Your Lordship. And even
but
the
isn't it the responsibility of the state?
Lordship,
Cannot tell me.
Yes.
We have already imposed a sizable burden upon Christian Medical College.
Yes, my lord.
They say that it has been for the last 4.5 years, they have been maintaining. There's no quarrel. But this I have done it only on the basis that the state at the end of the day would pay. Are you ready to pay that?
Lordship, for that matter, even the rights is not absolute. And even the parents also, they have the duty. Once the rights and the duty, they coexist, the correlates. When they do not do any duty, can we take all the burden, Your Lordship? Because whatever we have is a contribution from the public. So, Your Lordship, that also has to be taken into consideration. We have the limited resource.
A limited resource means you have to provide them something. Can the government say, because in India you still don't have anything else, till a person is alive, you have to give them the medical help.
True.
So
But
that is the
Lordship,
life.
yes, understandable. But it is
But
the
can
duty.
this court keep its eyes shut?
Lordship, it is the duty of the parents also to seek for donation or to seek for charity. They also should do something from their side. They cannot just give the baby to somebody that it is their responsibility.
Which we did, Your Honor. That's how lakhs were paid. Which we did, Your Honor. That's how we were able to pay lakhs of bills. Because our family, our friends, kindness, we were able to maintain. But
they have
once they
pay for the
completed
baby bills, not for the other.
Submission, my lord.
No, yes, for the baby's bills we
After
did.
getting the expert opinion, the baby can be shifted to All India Institute of Medical Sciences in Gauhati, who are having more than 100 departments, specialized departments within the northeastern states. So what I submit is, she had in one hand they are finding fault with the treatment. In another hand,
Mr. Abraham, listen. that this court understands the problems which your
Yes, Lord. Yes, Lord.
hospital is facing. This court duly understands that. But the fact
Yes, Lord.
remains that how, because as the mother says now, that look here, what is required is that she requires a ventilator and all these things, and the continuous presence of nursing in that regard. So therefore, this court cannot further continue. If that is so, why not the state of Nagaland provide that?
Your Honor, if I may, I do have a third option.
Yes.
Your Honor, my country, Portugal, is also a welfare state. So I've communicated with my embassy, and they have stated that if the baby is airlifted to Portugal, once she lands in Portuguese land, because I'm Portuguese mother, so I can make her documents, then she will receive all of her lifetime treatment in the hospital there for free, fully paid by the government. The only thing is they are not willing to pay for the transfer. That should be done from this side.
That is
Once the baby is there.
No, that is not possible. That you have to arrange by yourself. That is not possible. What you are asking is too much. That cannot be possible.
I think it would be cheaper than the state paying for the baby.
Cheaper means then you have to, then you can ask for the aid from Portugal.
Aid from the Portugal, yes.
Ask aid from the Portugal.
They will not because of the negligence that was committed.
The fact remains what they are concerned to look into it. This court is only concerned about here is as to whether the baby, how can the baby be continued to receive her support? Because under no circumstances this court can permit that treatment which is being given to her be removed. This court is also in a dilemma, taking into account that you cannot just put the Christian Medical College, after all, it is a private hospital.
It's a tri-party, Your Honor. It's tri-party with the state government and all.
We don't give any fund to the hospital.
Madam,
All the board members are the state officials only.
This tripartite thing is nothing mentioned in your petition. It is an order passed by.
No, it's mentioned, Your Honor.
No tripartite business out there. This is, I found it out and put it out there. But anyways, then the state of Nagaland is to look into it. That is the only way.
Lordship,
Because what is seen from this letter of aims, that the treatment which is being given, it is only a life support. There's nothing more than that. And what the petitioner says is it's only a case of life support.
Whether we have such facility in the government hospital or not, that's the question.
Yes, that is.
You have the facility. Because somebody has to do something, because you are the state.
For that matter, Lordship, I need to obtain instruction on that. Yes.
Thursday.
Okay. But it is also the duty of the parents, Lordship, to do from their part, to help the child. They cannot put the blame on the state or the hospital. And we cannot be vicariously liable for the Christian Medical Hospital, if at all there are proof also, Lordship.
If not for the negligence, my baby would be home and none of this would be happening.
The hospital, they clearly says that it's because of the
Okay, they said it, but they
has
provide
cancer because of that, Lordship.
That's a
She has
baseless
the cancer.
allegation.
She has the cancer because of that. The baby was prematurely born.
Right.
If he is taking advantage of the sympathy of this court, we have to look into that, Lordship. See, no advocate come forward to defend the case. The legal aid service were provided to them, Lordship. That's the attitude, the behavior. We have been so patient with them, Lordship. So, Lordship, those things has to be taken into consideration, Lordship.
The hospital has claimed that we have verbally harassed them, threatened them, even physically abused their staff inside of the ICU. Sorry, Mr. Abraham, please allow me to speak. They have filed it in the police. We have told the police, because we also filed our complaint, that please go ahead and get the CCTV. The judge ordered them to reserve the CCTV footage and provide it to the police. They said they would, they still have not. with that, there's so many CCTV cameras inside of the ICU. I think there's at least, that I can remember, 5. They can show it, they can provide it to the police, go ahead and provide it to the court. Where have we ever threatening and hitting them, physically abused? They try to get us arrested, Your Honor, with these false allegations. And it's claiming that it's an FIR, no such thing was registered. The police said they haven't registered because they have not received any evidence. They cannot simply file an FIR against us without evidence. They have not given them the CCTV footage of us hitting them, physically abusing them. Where is that CCTV? I ask Your Honor, I beg Your Honor, please pass the order, let them provide the CCTV from those dates where they say that we physically abused them.
We are concerned about the baby. Don't bring to those.
But we're being harassed by them, Your Honor. Even a threat of arrest, Your Honor.
You see, I'm not concerned what Mr. Ibrahim is saying, what you are saying on all this thing. I'm only concerned as to how the baby can be given a treatment, and further not to keep on burdening the Christian Medical College any further. The state has, if it is a case that you only require an ICU as well as the regular treatment which is being provided, they will provide the details, and the state has to provide, and let the state provide if they have it.
Ames has also said that it can be
within a certain limitation only, the price, the fix.
Huh?
Because
Okay.
under the Christian, under the Chief Minister insurance scheme, for a person like them who is not a government employee, they have the scaling of up to 5 lakhs only, Lordship. So beyond that, Lordship, because everything is a contribution from the state, Lordship, that also has to be taken into consideration.
My lord, one sufficient. My lord, one sufficient from me.
Whatever may be.
One sufficient, my lord.
The state.
My lord, if you take away the emotional aspect of this one, if you peel away the emotional aspect of this case, what remains is a contract between two parties.
a breach contract, Your Honor.
As per the privity of contract,
We breached the contract.
as per the privity of contract.
You to take out B, D, E, and F, because this is the allegation.
Yes.
You see?
Yes, Your Honor.
That is why your earlier lawyer did the right thing, taking out D, E, and F. Because D, E, and F is the problem. If you have D, E, and F, it gives the flavor that you are one pecuniary.
Yes, Your Honor.
You get the point?
Yes.
Yes.
As per the principles of.
Remove this good so that we can now concentrate on the baby.
Yes, Your Honor.
As per the privity of contract.
I'll come back in 5 minutes. Mr. Abraham, can you ask your client
My
to
lord.
provide me on Wednesday
Yes, my lord.
what is the treatment presently given to the child?
Yes.
Then I can take a decision on that and ask the state to look into this aspect.
Correct. Yeah. Obliged.
Yeah,
I shall do it.
that would be better off. Huh?
Yes, sure.
The treatment given to the child.
Wednesday.
And I will ask the state also to provide a detail. After that, as regards who can be the persons who can be put for the purpose of making an inquiry as regards as to whether there was any negligence initially. And if so, if it is negligence, it is okay, we'll take care of it. Now, the second is if there is no negligence, what are the steps which can be taken for the purpose of keeping the child? Means what are the steps which are required to be taken?
My lord can restrain these writ petitioners. My lord can restrain them from making defamatory declarations or allegations against the state, against the people, and against the hospital. Restrain them.
I've not made any claims against the state or the people, only against the hospital, which I've backed with evidence.
Can you get me this citation 2024 3 GLR 16? The book. 2024 3 GLR 16 16. So, madam, again coming back to the square one, what do you have to do with regard to lawyer?
Pardon,
What do you want to do with the lawyer?
Your Honor, as far as IA 65 and IA 58, we would like to withdraw it, like you said.
Okay. So that you will withdraw.
Your Honor, the only thing is, the lawyer has stated in writing and in open court that
No, I'm
the
asking.
second that it's retracted, she's gonna file defamation against
At
us.
the end of the day, I'm asking you what you want to do. That is what I'm asking. Did you get the judgment? Huh? 24? IA, which are the 58 and 65?
Yes, Your Honor, as you advised on Friday.
You don't need to withdraw 58. I'll pass an order in such a manner that the relief of D, E, and F is already there. You're only concerned about that D, E, and F was removed. Huh?
Your Honor, we will take your advice and we'll approach the
D,
consumer
and F
forum.
was removed.
Yes.
So D and F, I will bring it how it will be remain as it is. You don't need to withdraw 58. I will take care of it. What is the other one? 65.
Yes, Your Honor.
My lord, I have received a message from my client that AIMS Gauhati is having a pediatric neurologist. They are having a pediatric neurologist in AIMS Gauhati.
No, you need, I think the best option is to take the help of a pediatric neurologist. But the state has to sponsor his coming to for looking into it.
Yes, my lord. Yes.
Your Honor, and a pulmonologist. And the pulmonologist. Because she has chronic lung disease on ventilator.
Pulmonologist, PUL, pulmonologist.
Pediatric lung specialist.
Okay. So
Those two.
can you, Mr. Abraham, can you give me on Wednesday the details of the pediatric neurologist and as well as the
Yes, Lord. Yes, Lord. I will do.
Pulmonologist.
I will do.
So you give me that and let me put it out there. First, let me write 65 and 58. One order. Both these applications are taken up for disposal by this common order. The interlocutory application number 58/2024 is filed by the petitioners seeking reinstatement of the prayers in the writ petition being D, E, and F, which were withdrawn on the basis of an application being filed, which the petitioners state that the same had been filed without proper information given to them, without the petitioners being duly explained about the effect of the said application. IAC number 65/2024 is an application filed by the petitioners seeking an inquiry upon seeking initiation of criminal proceedings against the opposite party number 7, who is the counsel who had earlier represented the petitioners in the accompanying writ proceedings. The petitioners herein are present in person. This court also heard Mr. S. Abraham, the learned counsel who represents the respondent number 1. Let this court now duly take note of as to what are the reliefs sought for in D, E, and F. In the relief, what are the reliefs which were sought for in D, bracket D, D, E, and F of the writ petition? The relief so sought for in prayer number D is a direction upon the respondent number 7 and 8, who were subsequently arrayed as respondent number 2 and 3, to take appropriate legal action against the respondent number 1, as well as those doctors who were earlier arrayed as respondent numbers 2 to 6. It is relevant to take note of the relief which have been sought for in prayer number C, which is a relief, which is a direction sought for conducting an independent inquiry in respect to the negligence committed by the respondent numbers 1, 2, 3, 4, 5, and 6. Which have resulted in the complete disablement of the child of the petitioners. In the opinion of this court, if the relief at serial number C, at a prayer at C, upon being issued, and there is a report of negligence, the consequential actions would therefore automatically follow as to what appropriate directions can be passed when there is an apparent negligence. The relief number E and F relates to issuance of directions upon the respondent number 1 and 2 to reimburse the medical expenses paid by the petitioner to the hospital for treatment of the daughter and to waive the pending bills of the petitioner's daughter incurred in the respondent number 1's hospital. Full stop. It is relevant to observe that since 6/2/2022, since 18/2/2022, till date, the respondent numbers 1 admittedly have been incurring all the expenditure towards the treatment of the baby. And as submitted by Mr. S. Abraham, the
Yes,
learned counsel hearing on
Abraham.
I'm sorry. Learned counsel appearing on behalf of the respondent number 1. The bills of the petitioner, as on date, it has surpassed rupees 1.2 crores. Full stop. Under such circumstances, the relief which have been sought in prayer number E and F have already become infructuous. Full stop. Even otherwise, if the report which is being submitted pursuant to the directions passed by this court in respect to the prayer number C is found to be in favor of the petitioner, thereby showing that there was a negligence on the part of the respondent number 1. Consequential directions can very well be issued. Considering the above, as the reliefs at D, E, and F are only consequential upon any inquiry being conducted, on the report of an inquiry to be conducted, the withdrawal of the said reliefs would not prejudice the petitioner to get the benefits if, in the circumstance, the report is submitted, a report pursuant to an independent inquiry is submitted, is given, that the respondent number 1, as well as his doctors, had failed to, and its doctors were acted in gross negligence. Under such circumstances, this court, therefore, is of the observations that the instant application, being ISC number 58/2024, can very well be closed. First. Next. The petitioners who are present in person submits that their entire anxiety is the welfare of the child, and how the child can be given the appropriate treatment so that she can continue can be given the appropriate treatment. The petitioner in persons, therefore, submits that the application dated, the application being ISC number 65/2024, though has merits, but they would not like to digress from the main issue, that is the life and protection of their child. And as such, they would not like to further proceed with the said interlocutory application number 65/2024. Taking into account the above, the interlocutory application number 65/2024 therefore stands closed. This is done for these two. Now let's take the main petition. I've heard the petitioners in person, as well as Mr. S. Abraham, the learned counsel who appears on behalf of the respondent number 1. This court also heard Ms. Sukroy, the learned additional AAG. Learned AAG. I didn't want to make it double A, triple A. Okay. The learned additional AG of the state of Nagaland. It may be relevant to observe that at the time when the writ petition was filed, one of the grounds taken by the respondent number 1 that the baby of the petitioner cannot be given further treatment, it is on the ground that there was no treatment available in the Northeast. However, during the course of the hearing, the petitioners have placed before this court a communication issued on 18/4/2022 by a report dated 18/4/2022 given by a panel of doctors to the Union of India Ministry of Health and Family Welfare. This you have not brought in till now?
No, Your Honor, it was submitted by the union to this very court.
No. Is it on record? No, no?
Yeah, it's on record. The union submitted to the court.
Okay, it's there.
There's an order connecting to that.
It was during the time when the baby was about to be airlifted to AIMS.
Thank you. From the said document, report, it transpires that the treatment which have been meted out to the child by the respondent number 1 appears to be appropriate. And there would be no necessity of transferring the baby to AIMS, as it would not change the overall outcome. It was also mentioned in the said report that the baby can continue to remain, continue to evade, be given the same treatment locally. Full stop. Further to that, it is also mentioned that the case that the case of the baby does not fall in the purview of rare diseases. Under such circumstances, this court fixes this matter again on (49) 2025 at 2 p.m. Full stop. Mr. S. Abraham, the learned counsel, who appears on behalf of the respondent number 1 is directed to provide place before this court as to what present treatment the petitioner, the baby of the petitioner, have been provided. Full stop. This court further, Mr. S. Abraham, the learned counsel appearing on behalf of the respondent number 1, submits that the same would be duly furnished before this court on the next date. This court further directs the respondent number 2 to provide details of the provide details of 2 persons, 2 doctors, who would be in a position to carry out an inquiry in respect to whether there was any medical negligence on the part of the respondent number 1 in providing the treatment to the baby of the petitioners.
Your Honor, that I will be bringing before the Consumer Forum.
Then nothing will remain. See, let me do it. I'm giving you, I'm giving them the direction. You don't want to press C.
Your Honor, you advised me on Friday to take it to the Consumer Forum.
You want to do it for Consumer Forum, you do one thing, let them first get that detail. Okay? I'll pass an order. I'll take care of you, don't worry.
But all of the evidence hasn't been submitted because it's a continuous course of action. There's been more negligence after the filing of 2022.
Understood.
Like, for example, ghost surgeries. Surgery done to my baby. We met and signed with the ENT permission to do surgery. A different doctor done it secretly without us knowing. We have gathered the evidence of that.
Madam,
so the inquiry will not have all the details.
No, as regards how do I take care of the DEF, you
That's why we would like to go to the Consumer Forum.
DEF you can go. Let me pass an order. You'll find it out. Yes. Clear. Response number 1. As regards, we direct this court directs the respondent number 2 to provide details of 2 doctors who can inquire as to whether there was any medical negligence on the part of the respondent number 1. First, upon hearing the counsels, this court also directs that the said doctors should be should be neuropediatrics. What is that name?
Neurologist,
Pulmonary, PULMONAR.
Pulmonologist, I understand. And the other one is?
pulmonologist,
Okay, I'll leave that. A pediatric?
Neurologist.
Neurologist. Pediatric as well as the neurologist.
Your Honor, a pediatric neurologist and a pediatric pulmonologist.
Huh?
Adult,
Pediatric?
neurologist, the brain, pulmonologist, the lungs. Adults,
Pediatric neurologist.
pediatric
Yes, my lord. Correct.
And pediatric pulmonary.
Yes.
Correct.
Doctor in that. Whether we have that doctor in that.
I think
I'm asking you to provide the details, whether you have or not you. Madam, you look into the judgment of mine.
Yes.
In Binoy Deka. He will give you
Okay.
how it happened. First of all, list accordingly. Mr. Abraham, on the next day, I will pass some orders taking care of your situation.
Yes, my lord. Much obliged. So, my lord, 2 o'clock, after 2 o'clock, my lord,
At
on
2
4th. Morning.
Not on 4th, I'm having it on 3rd or 4th.
4th.
Thank you, Your Honor.
Yes.
For hearing, item number 13.
Etu duta hobo beleg. Eta whole 58 or 65 beleg ke order awaited. Yes.
Like we're out of time, Your Lordship.
Huh?
It looks like we're out of time, my lord.
What is it? 4:45 isn't that time? Anyway, no worry. I think I have done something a long day. Yes, Mr. Gupta, what are you doing?
My lord,
Which item?
my lord, I'm appearing item 16, my lord. 16.
At the end of the day, something good has happened.
My lord's patience has been greatly appreciated by a few of us at the back, my lord.
Some lawyers, however, say that I don't have patience.
Maybe circumstance, my lord.
This is item number 15, nah?
15.
Huh?
13. And our learned friend is mentioning the item number 16.
Okay. Mr. Gupta, what is it? Item number 16. Who is appearing? You are there? Yes, what is it?
Which dealing to compensation, land compensation. Railways have acquired.
Who has acquired?
Railways, railways.
And no payment made?
No payment. In fact, there was no acquisition process.
Is it, Mr. Gupta?
Oh, no, my lord. My lord, this matter, actually, my lord, it's a very old matter. And the payments have been made way back in the year 1992. Now, my lord, these petitioners have come again seeking compensation. And in fact, my lord, the writ jurisdiction would not be applicable, my lord, if even in case, presuming that they are entitled to compensation, my lord, they ought to have filed the reference application, my lord, under the provisions of the Land Acquisition Act. And my lord,
put their
the documents on record clearly reveals that.
If you're watching, can you have it tomorrow?
Huh?
Tomorrow, you're watching. Can you have it?
Tomorrow
It's
is?
convenient for this group.
The question is whether there has been an infraction to Article 300A is the question. It's a constitutional right. If we see the judgment of Vindhya Devi, state of Himachal Pradesh, that was done in 1973 and the Supreme Court passed the order in 2021.
Sir,
No, no,
this is
the
1992,
acquisition
we are
was,
just in 2024.
the money has been paid, my lord. It's a now they are disputing it after so many years, my lord. That is also surprising how they have come. But from the records, I will show, my lord, there are documents on record which says the amount has been paid to them, already paid to them.
Amount has been paid to whom? Somebody else.
No, my lord, the concerned person itself. How
Hmm?
it cannot be to somebody else, my lord.
else also. Because it's not only the present petitioners also. There are several other landowners who have approached. But the state has filed an affidavit and very clearly knows that no compensation has been paid to the petitioner.
Clearly time barred, my lord, and they are hit by delay in latches, my lord. They have to explain why they were sitting for so many years, my lord. If they were entitled to compensation, my lord, they ought to have come before the court earlier. Although, my lord, my case is that they have received the compensation. There are documents on record to show. And if they are now saying, my lord, after so many years, my lord, they should have explained the delay first, my lord, before approaching this court under Article 226, my lord. Delay is nowhere explained.
Now, it was for railways. And the railways have taken the possession. And what were you doing all this while?
They have paid the match compensation.
Huh?
The match compensation. The match to the properties, but to the land.
They have paid to the?
The match properties has been paid also.
So they have paid only on the Zirat, but not the land.
Not the land.
So how can you raise this here? This is what comes within the ambit of inadequacy of compensation, which comes within under 18.
First place also very political. Their case also. It is right important. Stated that there's no the question of delay in lashes does not arise. And it is a continuing wrong also.
No, very well. The delay in latches will not allow, but the fact that if you have not been paid or anything to that effect, but they have paid, what were you doing?
On the very first instance, watching.
You knew about this thing. They have taken the land only into 1992. What were you doing all this while?
They have legally occupied.
Huh? What steps did you take then?
We have been approaching the authorities.
Something written. Something written.
Also, I have clearly stated in my petition.
You cannot say that. This cannot happen like that.
And there are communications between the two authorities, the railways as well as the state also. There are communications. They have admitted also. In fact, the ADC of that particular town also, they have raised the question before the authorities. Address my grievances, lordship.
At page 40, if my lord will see, there is a communication on record that clearly says, my lord, that the.
Have it on some other day.
My lord.
I'm a bit lenient towards the landowner. So not for me. I try to give something or the other. Let's not have it. I gave a judgment on this. You have a look at State of Mizoram versus Darthunga. Have a look at it. It is reported. It's a very interesting judgment on the rights of the tribals. It has a very important aspect. Have a look at it. Because this aspect, what has happened in Mizoram, there were a lot of acquisitions done in 2002, 2003. There were all these land for the 2 real project. Now, these were done in the forest areas and more. The question arose as to whether they can get the lands acquired in this manner and whether they are entitled to compensation, because in reserve forest, you don't get a compensation. Now, in that case, I did take into account the 2006, bringing into account that you see there has been certain historical injustice done and all these things. And somehow I gave some compensation. So therefore, I'm very pro-landowner. So better I should not take up, delay the matter. Na? What do you say, Mr. Singh?
Can my lord please mention the name of the case again? State of Mizoram
State
versus.
of Mizoram versus Darthunga.
Chalo,
My lord.
we do one thing. Okay, we have it some other day. When? When do you want? You have to come to
My
Kohima.
lord.
We can't hear you properly.
My lord, my lord, as per Lord's convenience, next week, third week, not third week of September. It's okay for my net friend.
You
my
need
lord.
a particular date as you are an outstation council.
My lord. Thursday today. Third week of September. 16. My lord, 18. My lord, 18th, my lord.
Okay, it has been submitted by the parties that a matter be fixed on 18th of September 2025 so that the matter can be disposed of on 18th of September 2025 for hearing. Accordingly, the registry is directed to list the matter on the said on 18th of September 2025.
Obliged.
Item number 13, my lord.
13? Oh, this is 13. Oh, I was holding into another file. Okay.
My lord.
What is the matter about?
Invalid pension of maybe invalid pension.
Huh? It's a
Invalid pension.
so many orders passed. What is the case about?
Sir, for 7 years and
Disability Invalid Pension Home Department. Why disability?
40% disability eyesight.
Declared medically unfit by the medical officer, police department under the mention individual are hereby enlisted as so and so. The service of the carriers are so and so. Purely and temporary and is terminable with 1 month's notice. Allotted battalion regiment number till further orders. Declared unfit, medically fit. So you have been declared medically fit.
Yes.
Then?
At the time of training.
Then why you have not been given the when were you discharged?
If your lordship, can you come to page 15, lordship?
Page
15, 1-5.
eyesight.
Yes, lord.
Certified that so and so 35 years of Iman in Yemen, Borneo high years, so and so permanent physical year disability. So this is done by the medical board.
Yes, lord.
Then
The next week, we were also acknowledged by the.
or I said due to so and so. Then resignation tendered by so and so of the unit is hereby accepted. Accordingly, he struck off from here. Now you didn't want to resign. They made you resign. Huh? Then now they are not paying you a single penny. That is the question.
Yes, lord.
But what were you doing from 2005? 15.
We started in year 15.
Then why? Then you filed a writ petition in 2021. And you have been given, I think the 1,49,900 is the gratuity, the terminal gratuity.
Lord.
And you have not been given the invalid pension.
Yes.
And you woke up to ask the invalid pension in 2021. How many years did you serve?
7 years, lord.
But how do you take care of your resignation? Huh? The problem is your resignation. You take care of it. And you have not withdrawn. Because you see, if I'm not wrong, I'm taking up another matter on 4.9, invalid pension. Mr. Im Song is appearing. Or as well as disability pension. There you are taking the judgment of Dharamveer Singh,
Lordship,
isn't it?
Lordship.
But Dharamveer Singh comes in respect of army, where the onus of proof has been put upon the employer.
Employer, Lordship.
But there is another judgment. You look into the judgment, Bijender Singh versus Union of India, reported in 2025 SCC Online SC 895.
Is it either 23rd April 2025?
Huh?
Is it 23rd of April 2025?
Most likely. Bijender Singh?
Yes, Lordship.
Ah, that one. You are relying on that?
Yes, Lordship.
Okay. So you know better. Okay. Here they must have taken the plea that you have resigned.
Yes, Lordship.
And that is why you have not been given.
Yes, Lordship.
And you were employed as?
Constable, Lordship.
And what was your education?
Graduate. Male graduate.
Graduate. Then I think you must be knowing the implication.
Lordship. Lordship, in my application, of course, the term varies here, Lordship. My application, which was finished by the state.
So here we'll have to look into as to whether your application, whether your was it your intention to look to get yourself terminated? But you are a graduate, so therefore you could have done it immediately thereafter, but you didn't do it. How can I help you?
Lordship, I have also stated my medical condition, Lordship. In my
medical condition, a person can file a writ petition after 6 years, he improves his eyesight. Something must be there. How do you take care of that? He must have improved his eyesight most probably. 7 years, you should have had minimum 10 years. You should have known that. And 2015, they have come up with an office memorandum. Isn't it your case? Huh, Mr. B. Momi? They say that the office memorandum is there. And you resigned when?
2015.
15?
September.
And they came up in March. Isn't it? See? You should have known that. Another 3 years, they would have either thrown you out, then you would have been entitled to.
That point is such the legally after by the state.
You have not brought in?
Yeah, not that.
That is their main case is that even if you are otherwise taking, they have 7 years of service and you need 10 years for getting the invalid pension.
Qualifying years. As far as 38, Rule 38 is concerned, Lordship, there's no period of severance.
Understood, but you did it subsequent there to.
I'm relying on one judgment of this honorable board, Lordship, which I've enclosed in page number 26. A similar severity, Lordship.
Page?
Page 26.
Is that a case for withdrawal? Resignation? Yeah, this is a judgment subsequent prior to that, na?
Lordship.
Problem arises because of that. Mr. Jimomi, what is the date of your office memorandum?
Lordship, that we have not annexed, Lordship. So, Lordship.
You have not taken that as a plea.
Lordship, I have taken the plea with regard to the delay in lectures, Lordship. We have raised a preliminary objection, Lordship. In the course of hearing, Lordship, now the commandant who issued the resignation order becomes a necessary party, Lordship, and they have amended the instant writ petition, Lordship, by cooperating respondent number 5, respondent number 6. So, Lordship, I'm waiting for that instruction, Lordship.
You want time?
Lordship, since instruction has to come from the commandant respondent number 6, who is the needed respondent.
Counsel appearing on behalf of the state respondent submits that in view of the amendment filed to the writ petition, he requires some more instructions in the matter. Mr. What do you have to say?
My lord,
You are the Accountant General.
yes, your lordship.
You are going to issue the check.
Your lordship, the issue is that he had submitted his resignation.
Okay.
So that's why.
Mr. Jeseki appearing on behalf of the Accountant General submits that the Accountant General shall act as per the decision of this court,
My lord.
or such directions as may be issued by the, or such proposal being submitted by the respondent authorities as per law. So, taking into account the above, lists this matter again on when? 19 September. In the meantime, the respondent shall obtain the instructions and file their affidavit, if any, by on or before 15th of September.
Blush, your lordship.
2 weeks. You have objection?
No, my lord. I've already filed my affidavit.
Item number 18 and 19, the request of the learned counsel for the petitioner. Matter stands adjourned to be listed again after 2 weeks. Mr. A. Santam, the learned additional AG,
LG Santa.
submits that the affidavit of the state have already been
Yes,
filed
Yes, my lord.
after 2 weeks.
Yes, my lord.
Yes, what do you have to say?
Article 70, my lord. I don't know what happened to this case. Nearly 5 days they came, and actually today I have come on this here. I am having my some treatment in Liverpool. Then again, my missus is treatment in Gauhati to Dr. Rheumatic arthritis.
Now, what do you want?
I thought that it would be tomorrow. If your lordship kindly allow me to appear to BC.
What is the matter about?
Matter is one eviction notice was applied to me, directing to take away my house and other belongings
Why?
in Khawai village.
In?
Khawai village. In Khawai village. Actually, your lordship, I have not been served with any notice. No shockers notice was given. Nothing.
You
Only
have got a stay. You have got a stay.
Yes.
Hello, we take it up tomorrow. We take it up, no problem.
My lord, I may be allowed to because I am having backache. I am coming but Bimbo.
Do whatever you feel like. You want to do it tomorrow, I'll take it up. I have no problem. Can we finish up in 10 minutes?
Yes, I want to finish it.
10 minutes?
Tomorrow.
Stay over. Where you are going? Can finish up in 10 minutes? This
Yes, your lordship. It will not
eviction matters doesn't take much time.
It will not take much time, your lordship. Much less, your lordship. Your lordship, page 24 is the impugned order, your lordship. Eviction 5, page 24.
Whereas the office of the commissioner so and so have given approval for eviction of unauthorized structure newly remand. Whereas so and so hereby strictly to enforce status quo and refrain all parties from carrying out fresh activities, you are hereby directed to dismantle the illegal structure and vacate the area along with the structure and belongings within 14 days from the date of receipt of mail. Then?
Your lordship, I am there since 2018, your lordship, in Khawai village.
So?
Khawai village is a village land, your lordship. Village land. And your lordship will appreciate that the notice has been issued under signature of 2 additional deputy commissioner. One is Peren, another is Chumukirima. Now, your lordship, I have not been served with any prior so-called notice or any opportunity of hearing has not been given to me, your lordship. At least your lordship, I should be given an opportunity of being heard.
So what right do you have over the land?
It is a village land, your lordship.
So village land can you occupy like that?
No, I have not occupied. I've been given village patta, your lordship.
Where is that patta?
Village patta is your lordship, NHR 1, type copy, page 19.
That so and so was married in the year Iman came to Iman in the year for permanent settlement. Accordingly, the GB of the village allotted him a plot of land measuring an area of 2,880 square feet, which is bounded by so and the land is allotted to him and who has given the head GB.
Yes.
And whereas a report has been issued, received from the Commissioner Nagaland, the serious law and order is apprehended after the reported activity for establishing a new settlement by the name of Lamai Namdi.
Lamai Namdi. It is
Who
a
is
new
he?
village.
Ah.
I'm in Khewai.
Whereas the boundaries between Dimapur and Pheran are yet to be demarcated and land dispute between Lamai and which so therefore it is hereby ordered that status quo shall be maintained by all parties. Yeah. Then what
Then,
happened?
your lordship, there was an internal communication between commissioner and the deputy commissioner, but no notice was served upon me.
Yes, what do you have to say, madam?
The plea that the petitioner has not been effort herein is wholly misconceived.
Huh?
The petitioner was already under a subsisting status quo order.
Already under?
Under a status quo order.
Ah.
Yes, that was issued in the year 2019. So, your lordship, no rights will flow from the illegal act.
No, it's
Because
okay.
yes, your
No,
lordship.
the question is whether, what do you say about that, the settlement being given by the head GB?
Your lordship, the area is still in dispute. The subject land is still in dispute, and therefore status quo was already promulgated by the deputy commissioner.
Okay.
Your lordship, may
You see,
please
madam,
that,
the thing is like this.
Lordship,
A thing which could have been done within a 15 days time
lordship.
is now you are getting a status quo for the last 2 years.
Yes, lordship.
So the best option is you do one thing, you let him submit a representation to the deputy commissioner or the additioner.
Yes.
Let him submit you give him.
But no, I mean, like the petitioner failed to demonstrate that he has been prejudiced. Because the status quo is already there, he is under a status quo order.
No,
And now he's taking a plea that he had no knowledge about the status quo order. So when he violates the status quo order, the question of principle of natural justice does not arise, your lordship.
No,
Madam, the problem is not that of the status quo violation or principles of natural justice, but if you see the judgment of the Supreme Court in Inri demolition, the Supreme Court categorically means that you have to issue a notice, give him a hearing, and thereupon you take a decision. And if you want to throw him out, throw him out.
Lordship, that yes.
Now, the thing, what is happening is, because of this pendency of the instant proceeding, he's taking the benefit.
Yes, that I understand.
A thing which could have been done in 15 days,
yes.
You are giving him this. So let me pass an order by which he will, within 10 days, let him submit a representation to you on the or reply to the show cause notice giving him his case. And thereupon you take a decision and thereafter whatever you want to do, do it.
No
My
notice was,
objection may be recorded.
no suppose notice was ever issued to me.
No, now they have given us direction that you should be evicted within 14 days. They gave you that direction.
yes.
Now you do one thing, you file a reply saying that what is your right over the land, and they let them take a decision and do whatever is necessary. Matter over.
Yes,
Lordship,
yes,
my objection may be recorded and yes.
That is the objection.
Yes.
No, that question is, you see, if I go into those objections, there is no problem in that there is nothing out there on merit. Because if I do that, the problem is, if I send him there, you will be prejudiced, no? You will always be biased. So if I put that, it will have an impact. I know you will always be biased, but let him do that. He has come on a technical ground. So let the technicality be corrected.
Lordship.
But if I say that put your submission out here, it will have an impact tomorrow, that they will say that they were already biased and as such they rejected it. Get my point? So we put it out there that within 10 days, he will submit the year to the additional deputy commissioner.
Yes, yes.
And Chumukidima, and the
Yes.
additional deputy commissioner thereupon shall consider by giving him a hearing. And then the decide as to whether the petitioner have any right over the land for summary of eviction.
Yes, Your Lordship.
Heard,
In the case, Your Lordship,
Huh?
there are pattern of judgment where principle of natural justice is being discussed by this honorable court as well as that. Menaka Gandhi case, without giving an opportunity, one should not be taken away his constitutional right under the.
Why is Menaka Gandhi case important?
Because the principle of natural justice. Your
How does principle of natural justice come into the play in Menaka Gandhi?
There, of course, Your Lordship. There,
How?
that passport issue was there.
Understood. How?
Yes.
You have
Yes,
the
Your
law
Lordship.
has to be developed.
Because
The law has been developed in Menaka Gandhi. The first was a judgment of Justice Fazal Ali. Then that was in 1969. Then comes in Menaka Gandhi in 1978,
78,
whereby Article 14, 19, and 21 were read together.
yes, yes.
And thereby the aspect that without following the due procedure of law have been explained to mean that without following the natural justice was brought, principle of natural justice was brought within the ambit of Article 21.
Yes, yes.
And therefore it becomes a constitutional fundamental right.
Fundamental right. Yes, Your Lordship. Whatever this Lordship will.
No, I
authorize.
said that
But
3 minutes, I'll dictate the judgment.
much of.
Heard Mr. P.B. Paul, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers 1 to 6. The petitioner herein is aggrieved by the communication dated 15/11/2023, whereby the additional deputy commissioner, Jaluki,
And parent.
Jaluk.
Jaluki,
Yes,
Jaluki and Chumukidima.
Chumukidima.
as well as the. Now, these are two different orders.
Your
Your
Lordship,
Lordship,
this is the funny thing, Your Lordship. This order has been issued.
You are challenging which Annexure 4 and 5?
Yes.
Both.
Jointly issued, yes, by the Deputy Commissioner Chumukidima and Jaluki.
No, you
The
have only
eviction order.
no, you have only challenged
Challenge
15.
this 15/11, yes.
15.
15.
Whereby the additional deputy commissioner Jaluki Nagaland had directed the petitioner to dismantle the illegal structures and vacate the areas along with the structures and belongings within 14 days from the date of receipt of the said notice. Full stop. The learned counsel appearing on behalf of the petitioner submits that the said action, the said eviction notice order dated 15/11/2023 have been passed without giving an opportunity of hearing to the petitioner. And as such, the same violates the very mandate of violates the article, the principles of natural justice, which is a facet of Article 21 of the Constitution. Full stop. Ms. Emery, the learned counsel appearing on behalf of the respondent submits that the basis on which the petitioner claims any right over the land has no legs to stand. More so when the petitioner have already have claimed the right on the during the existence of a status quo order, isn't it, madam?
Yes, yes.
Full stop. This court, having heard the learned counsels appearing on behalf of the parties, is of the opinion that the order of eviction dated 15/11/2023, admittedly having been issued without notice being issued to the petitioner, the said order is required to be interfered with. Full stop. This court, however, cannot also be unmindful of the fact that the respondent authorities duly have the authority to evict, to carry out eviction of unauthorized structure if the petitioner do not have any bona fide claim of right involved. Considering the above, this court therefore interferes with the impugned order dated 15/11/2023 and disposes of the instant writ petition with the following observations and directions. The order dated 15/11/2023 is set aside and quashed. Number 2. Taking into account that it is the claim of the petitioner that the petitioner have not been issued any notice prior to the issuance of the order dated 15/11/2023, this court grants a liberty to the petitioner to submit a representation to whom?
Additional Deputy Commissioner.
Yes.
Kohima.
Additional Deputy Commissioner.
Kohima and
And
There are
Parent.
two additional Deputy Commissioners.
Yes,
Whom should we give?
to both.
No,
Because
one.
this is jointly
Let one person
issued.
decide.
Okay, Chumu,
Huh?
Chumu Kedima.
Sumekediba. To where is the land? Within whose jurisdiction?
That is in dispute, that's why, Your Lordship.
No, then
Parent is also claiming that it belongs to their jurisdiction, whereas Chumu also claiming like that. So that is yet to be decided.
That is a village.
That is-
Your Lordship.
that is
After
yet to be
Kumika's
decided.
story,
no, anyways, he
Jurisdiction
can
is
raise that. Let him give in
Yes.
to the to additional Deputy Commissioner Sumukedima, Nagaland. Bringing on record his right to remain in possession of the said land, in respect to which the eviction order was passed. Eviction order dated 15/11/2023 was passed. Next. The said representation be submitted within a period of 15 days from today. Next. The additional Deputy Commissioner, Sumikedama, is directed to give an opportunity of hearing to the petitioner by fixing a date, and thereupon shall decide as the said representation in accordance with law. Next. This court further observes that in the circumstance, the additional Deputy Commissioner, Chumikedama, Nagaland, is of the opinion that the land wherein the petitioner was possessing and in respect of which the eviction order was passed does not fall within his jurisdiction. The same be transferred to the additional Deputy Commissioner, Jaluki, Nagaland, who shall, upon transfer, duly intimate the petitioner about the date of hearing, and upon hearing the petitioner, pass appropriate orders. Both sides. With the above, the instant petition stands disposed. Finish. I told you only 5 minutes more.
For hearing, item number 15.
sorry, Your Lordship, we have
No, it's okay. I always sit till long.
much of it.
This I should not take any further.
Your Lordship, this is with regard to retrospective regularization. So if this matter can be listed after the disposal of writ appeal 234 of 2025, which is pending disposal.
Which one? That day? Oh, this one. Matter went to Supreme Court.
Yes, Your Lordship.
This matter went to Supreme Court and the question of law was
Yes,
kept
yes,
open.
Lord. Yes, Lord, that.
Now, there is a judgment which is awaited in Bab Jasimidul Kulta. Isn't it?
Writ appeal.
Yes,
Yes,
appeal
yes,
is pending.
Yes,
Because
Lord.
that day when I was sitting with the
Yes.
Chief Justice, then
Yes, this matter came up.
that was the submission which was made.
Yes, Your Lordship.
Okay, let us have this after when?
After the disposal of the appeal, Lordship.
Which appeal? Number
3 and 4, Lordship. Appeal number 3 and 4, Lordship.
3 and 4
Yes,
of
2023, 24, Lordship.
25.
25, Lordship.
list this, it has been submitted by the learned counsels at the bar that the decision in the instant writ petition, that any decision in writ appeal number 3/2025, which has been reserved for judgment by the learned division bench, will have an impact on the present proceedings. And as such, submitted that the matter be listed after the disposal of writ appeal number 3/2025. The registry shall accordingly list the instant proceedings after the disposal of WA number 3/2025. Finished?
The last sentence. Last sentence we have to show. Yeah.